at the request of.
May I please also?
Yes.
An actual 4 is pending before opinion number 2. The case is like that. I am the auction purchaser and I purchase the auction property. I am giving the entire amount 1,20,60,000 as per the page 9 and 10. And they also issue certificate of sale as per Annexure 2. Annexure 3 is a sale certificate also registered. But till date, neither they refund my amount nor hand over the physical possession.
You take emergent notice.
Or your lordship dispose of the Annexure 4 before the opinion number 2. Lordship.
To consider your representation.
Madam.
Annexure
4 is pending for opinion number 2.
You are auction buyer.
Yes, ma'am. I have purchased. Auction purchase, entire amount I have paid.
The auction buyer in a surfacey proceeding is knocking at the doors of writ court with the following prayers. Next paragraph. Learned counsel for the petitioner argues, and we agree, that the subject representation of his client for taking further steps in terms of the auction held on so and so needs to be considered by the OP bank in accordance with law. You are for OP bank? No. In accordance with law. First of all, representations of the kind cannot be kept in limbo ad infinitum. Argues the counsel. First of all. Next paragraph. Notice to OPs is dispensed with regard being had to the innocuous nature of the prayer, in as much as it is for passing order on the subject representation or a direction to pass order on the subject representation. All contentions being kept open. First one. Next one. In the above circumstances, this petition is disposed of, directing OPs to take a call on the subject representation within an outer limit of 6 weeks. 6 weeks. All contentions in that regard are kept open. It is open to the OPs to seek rescinding of this order if grounds do exist therefore, since we have seen this expert, grounds do exist therefore. First, registry to send a copy of this order by speed post to OPs before evening of tomorrow. Yes.
Right.
Maybe. Yes. What is the matter, Mr. Dash?
Order against this
appointed as assistant professor.
Yes, ma'am.
In physiology.
In physiology, the present petitioner is having the qualification. The required qualification was master's in physiology or a medical MD physiology. I am from the medical. That two category person can be recruited. One is from the medical branch and another from non-medical branch. If somebody has the MSc physiology in the subject, then also they are eligible. Here, this opposite party number 4 is a MSc, non-medical candidate, MSc in medical biology, sorry.
Not in requisite discipline.
Not in the discipline. But that is
notice. Let us see.
Mine.
Matter requires examination, paper examination.
Your Lordship, I am appealing for OP number 123.
Issue urgent notice. Looking at the CGC.
Yes, Your Lordship.
CGC volunteers to take notice for OP numbers 1, 2, and 3.
Yes.
First time, emergent notice to 4.
Ready? Into my house. That's all.
Yes, sir.
The son of the present petitioners obtained a loan from the opposite party bank,
When they took loan?
took loan on 24/9/2020,
24.
creating an equitable mortgage for an amount of 10 lakhs.
Is it a housing loan?
Housing, 10 lakhs. Mortgaging the property by the khata number 387/66, plot number 320. That is the household property. Household property.
What is the term of the loan?
Term of loan, my lord. The son of the petitioner are regularly paying since night.
You are not asking about what you answer our
Yes,
question.
yes. Period of loan, my lord.
Where have you studied? You have not studied the papers at all.
No, my lord. Annexure 2. Annexure.
We are asking not for an exam. We are asking you, what is the term of loan? 10 years, 15
By
years.
what time the EMI
Entire
was
should be paid back.
What was the number of EMIs that you were supposed to pay?
Ah,
My lord.
And how many of them you have paid?
That is that you answer.
My lord, one password, my lord.
Password.
Yes, one password.
Yeah, like, how many installments you have paid?
Installment up to 9/6/2025.
9625 you have paid.
9/6/2025 up to 9/6/2025. Outstanding amount only 8,96,629.
About 9 lakhs.
My lord. Prior to that, annexure 4.
So we want to give you relief unless you issue us not to grant. Now you pay 50% of the.
Yes, madam. I am ready.
How many accounts loan installments will be due?
My lord.
From 96 to
9/6/2025.
96 to 92. You can say 31/3, 31/1.
My lord.
How many? How many installments? Is it monthly installment?
Monthly installments.
How much?
My lord, actually,
So up to March, 7 installments are due.
7 installments.
Is it? What will be that total amount?
total amount, my lord,
Each installment is?
actually installment, the present petitioner has at end.
No, installment value. How much?
Value, my lord, they have
Lakh.
not reflected.
How could it be? You know you don't
Yeah,
know what you are paying as
You are
EMI.
not-
Monthly list, no, there is no specific. They have not specific mentioned.
You have not studied it. Anyway, you pay all the installments up to January.
Yes, my lord.
Huh?
Yes,
Within 2 weeks.
my lord. No, my lord. 15. Yeah, yes. In 2 weeks. Yes, sir.
15.
Yes.
Issue emergent notice. Learned counsel for the petitioner draws attention of the court to IA number so and so supported by an affidavit seeking interim protection against the coercive action. First off, he tells us that the loan is a term loan and it is for housing purpose. Savitula. Petitioner has paid installments up to 2025. And that he is ready and willing to pay all the installments that have fallen due till date if a reasonable period is granted. First one, there is force in this submission. Prima facie. First one. In the above circumstances, application having been favored, all coercive proceedings are kept at bay, subject to petitioner paying clearly all installments till date within an outer limit of 3 weeks. Within 3 weeks, you have to do.
Yes, ma'am.
First, issue emergent notice, returnable in 4 weeks. Petitioner is put to warning that in the event this interim order is not complied with, petition itself may be rejected. Yes.
Till date, no further action may be.
Yes, we have said. Always in banking matter, nature of the loan, amount of the loan, term of the loan, value of the installments, how many installments are paid, how many are remaining, why it could not be paid. These are the 7-8 questions. Beyond that, there is nothing. Yes.
My lord, in this case, my lord, the petitioner is a co-surety, my lords.
For surety.
My lord, he's the second guarantor, my lord.
Second guarantor.
My lord. Then, my lords, in this case, the writ petition is filed for the inaction of the opposite parties, my lords.
Huh?
On the inaction of the opposite party, my lord.
Opposite party is principal, the banker.
Banker, my lords.
What is inaction?
My lord, in the previous occasion, the petitioner has approached before this honorable court
Yeah.
for one-time settlement. And after hearing of the matter, this honorable court has directed to the opposite party to consider his outstanding amount at 7,55,000 minutes. Then, minutes, we have approached several times to the bank minutes. Now, my lord, they are not taking any, they are not, neither they are receiving the payments, nor they are giving any explanation, not they are giving any reply to us, my lords. Then, my lord, the fact of the matter is, my lords, a person, he is a principal borrower, namely Trilochan Mahanti. He took a business loan from the State Bank of India, Jharsuguda, minutes. Then for the purchase of machinery, business accessories, and business expansion, minutes. Subsequently, minutes, his account was NPA, and his property was auctioned, minutes. His movable property, minutes. Then, minutes, to recover the deficit amount, the opposite party, State Bank of India, have attached and auctioned for the first guarantor, minutes, at an undervaluation price, minutes. My lord, in this case, my lord, the opposite party bank has not complied the order, or not complied the rule 6, my lord. Rule 6 and 8 of the security interest enforcement rule, my lords. In this case, my lord, the opposite party neither give up the notice to us, the opposite party neither give a proper value, neither.
What they have done now?
My lord, they are not responding. We are ready to pay 7,55,000.
I have the instruction to take time, and thereafter, if a copy will be solved,
You give copy.
and matter will be taken next week so that we can give our response.
On next week, we should take this matter. Till then, we will not trouble him.
Millard, exactly what he says, what bank is troubling, what he's saying that he has given, what is version now, that OTS, and thereafter bank is not taking any action. So what action, unless I know, so how can I say?
Where the bank is?
Bank is in Jharsuguda.
You phone, call them and tell them.
So that's why your lordship.
Not 1 week. Will they come by road roller?
No,
You
Millard.
speak to them and tell us. Otherwise, we are staying at everything.
No, your lordship.
Yeah. Issue notice. Panel council is requested to accept notice for the OPs. Volunteers to accept notice for the OPs.
Now, instruction, Millard.
Yes, therefore, notice on instructions. First one. Call this matter a day after. Come on. Since counsel for the petitioner is pressing for interim relief. Okay.
A copy may be solved.
Call this on Thursday instead of tomorrow. Thursday only.
Millard.
Okay.
A copy may be solved.
Give him copy right now. Yeah. After giving copy, you have to stand here so that we will see that you have given the copy.
My lord,
Next.
may I please, lordship?
Yes.
My lord, the petitioner is a farmer before your lordship. He has availed a agricultural cash credit loan of 29 lakhs, your lordship.
Agricultural loan.
Agricultural cash credit loan of 29 lakhs, your lordship. Thereafter, he had paid 8 lakhs. Out of 29,
When that loan was taken?
on 22/9/2021, your lordship.
22/9/21. Is it a crop loan?
Agricultural cash credit loan, your lordship.
That's right. How many lakhs?
8 lakhs he had paid till February. Loan of 29 lakhs, lordship.
Of that, he has paid
8 lakhs till April 2024, your lordship.
24. Thereafter, what happened?
On 1/5/2025, the loan account was declared as NPA by the bank. 1/5/2025, your lordship.
Because you had not paid the
Yes,
installment.
due to non-payment of installment, it was declared as NPA, lordship.
Yes.
Thereafter, the petitioner filed representation to induct the loan account of the petitioner under OTS. OTS.
You offered OTS.
Yes, we offered the letter that is as per Annexure 2 series, your lordship.
Yes.
we offered letter. Thereafter, on 37/2025, notice under section 13(2) of the Surface Act was issued against us, Your Lordship.
37, 2000.
25, Your Lordship. Thereafter, also on as per Annexure 4. On 29/8/2025, again the petitioner requested to induct the loan account of the petitioner under the OTS. Now, Lordship, during pendency of this case, on 19/2/2026, when this the matter was called up here, the bank have taken possession of that mortgage property, that is the dwelling house of the petitioner. I have filed an IA that has not come on record. I had mentioned before the
You take emergent notice because possession is already taken. Therefore,
they have
restoration cannot be done.
Thereafter, they have threatened to evict us within 3 days. It is the dwelling house of the petitioner. The petitioner is ready and willing to pay, Your Lordship.
How much you will pay?
50%, Your Lordship. I am ready and willing to pay.
50% of the amount due.
Yes, the amount is 33 lakhs. 33 lakhs.
Amount due is what?
33 lakhs. As for the NPN notice, 33,30,462, Your Lordship.
33.34.
33 lakhs, 30,460. Your Lordship.
You will pay around 17 lakh now.
15 lakhs, he's ready and willing to pay, Your Lordship.
15 lakh.
Yes, yeah, he's ready and willing to pay.
Why not other 2 lakh? Generally, we have adopted 50% rule, na?
Lordship. Then
17 lakh you pay.
Lordship.
Within what installment? How many installments?
Within 3 weeks, Your Lordship, I am ready to pay.
Okay. Petitioner is
interim application.
Interim application is there, Your Lordship,
but
it has
not
not
to-
come up.
It has come now.
Yes, Lord. I have filed it on 20th, Your Lordship. That Annexure 5 is the
Petitioner
notice.
having taken agricultural loan on 22/9/2021 in a sum of rupees 29 lakh and having repaid 8 lakh, rupees 8 lakh, he is knocking at the doors of it for against the coercive action of recovery by the OPs under the provisions of Surface Act 2002. First one. Next one. Learned counsel for the petitioner vehemently argues that his house property that was mortgaged for securing the repayment has been taken possession now, symbolic possession now, on
19/2/2026.
19/2/2026. Seven. His client and his family are residing there even now. Semicolon. They are ready and willing to pay 50% of the loan amount along with interest that has accrued due till date within 3 weeks. Semicolon. Therefore, they need to be given interim protection from removal from the occupation of the property. First, a prima facie case is made out for issuance of emergent notice and for granting interim protection as sought for. Since next paragraph it is, a prima facie case is, since a petitioner is an agriculturist who needs to be handled with the soft gloves in this country, agriculture being the lifeline, why the apex court decision in so and so. First one. Petitioner appears to be a bona fide loanee since he has already repaid a sum of rupees 8 lakh, as argued before us. First of all. Further, he is ready and willing to pay 50% of the outstanding loan amount within 3 weeks. First of all. There is no reason to doubt the version of an agriculturist like him. First of all. After all, we are not staying the taking of possession, but protecting permissive occupation of the petitioner and his family for a short period, subject to the say of the bank on the next date of hearing. First up, it hardly needs to be stated that right to residence is one of the fundamental rights guaranteed under Article 19(1). What is that sub-article? Give him, not G. If you say do not know, you will be committing one wrong. If you say G, you will be committing two wrongs because you do not know what is that right, you do not know what G is. Give him, please let him read. Right. In the above, next one, in the above circumstances, the respondent bank is restrained from removing the inmates of the house till the next date of hearing, subject to petitioner paying the outstanding money within 3 equalized weekly installments reckoned from the state. Next paragraph, issue emergent notice with copy of this order, of this interim order to the respondents. Very straightforward. First of, requisites to be supplied today only.
Not.
Not within 2 days. IAD is on. Next, you have to bring which is that judgment which said agriculture is the lifeline of this country. Okay, you have to work now. Go to the library till they don't print it. Number 2, you have to say which judgment of the apex court said right to residence is a fundamental right. All right, you give both the judgments now. Don't go home now.
No, sir.
Yes. Next. Yes, sir.
Petitioner took loan, CC loan, my lord.
CC loan means
Cash credit loan, my lord.
cash credit. Is it what nature of loan? Cash credit is available even in marriage.
No, my lord, cash loan for business, my lord.
Business.
My lord. First is 2-1,
Business loan of how much?
first 15 lakhs, my lord.
Then
2-1-21 and another 9 lakhs, 24-12-2021, my lord.
January 21 is
15 lakhs, my lord.
15 lakh.
December 2021, my lord, another 9 lakhs, my lord.
December 21, 15th of March.
The account became NPA in 24-2024, my lord.
How many, what was the loan period?
But the CC loan, there is no loan.
Nothing like that. Permanently it will be like that.
No, my lord.
But tenant on loan, the banking law says is always a term.
No, sir. In CC loan, time period is not there. Only when they
Whenever apply, you will give.
that will be continue, provided he has to pay the interest on monthly basis. What is the amount he can use?
Anyway, may not be correct. Anyway, it's
So
all-
24 February 2024, account became NPA.
No, how much you have paid back?
My lord, and 5/3/2024 demand notice, my lord. Under section 32, the amount is 30,84,271, my lord. 30,84,271, my lord.
That was 3 years ago.
My lord, thereafter
2 years ago.
My lord, thereafter the petitioner regular paying, my lord.
How much?
Payment, my lord, more than
Well,
65%, my lord.
More than 65%.
My-
Is it true?
Sir,
Are you
actually,
for the bank
Man,
Yeah.
I have annexed the statement of account, my lord.
account also?
My lord, there shows my now 10,50,56,035 my lord is the remaining, my
It's
lord.
outstanding. Today we have to grant him in the model because he has brought the cheat. Yeah. Small cheat you have brought. We are very happy.
Man,
Yeah.
now
See, 65% of the loan is repaid. Why you want to trouble him?
it is not like that, not so. Actually, this is 2 loans they have taken, and they are putting single property against that same one, 2 loan. And they have missed the payment.
How much?
It is, although I have not received the copy, but still they have given a OTS to us that is 14,76,000 of OTS proposal was given by the borrower to us. But subsequently they have failed to comply that OTS.
Yeah.
So that's why bank has taken some initiation again.
I have OTS, my lord. That period, my lord, loan amount is 14 lakhs, my lord.
14.76.
476 lakhs, my lord.
That time, I have OTS, my lord, over 12 lakhs. They have not received my OTS. They have.
Why they should agree with you?
My bona fides only, my lord, 21, 2026, I have deposited 3 lakhs, my lord.
Huh?
20 January, my lord. 2026, my lord.
20th
I have deposited 3 lakhs, my lord.
Against that.
My lord.
Against 14.76.
My lord.
Whether OTS offer make it installment,
No, they have not.
one time settlement.
My lord. They have not any reply in my OTS scheme. My lord.
What OTS? They have said already.
They have not.
They have said 14.76. It was sent to him by registered post.
No, sir. They have just given a application in plain paper.
Offer they have given.
Without giving any caution money of that.
What is the caution money?
That is at least minimum 10% of the money they should give to
How
the
much it
for
will?
the proposal acceptance of the proposal of OTS.
About 3 lakhs it is.
They have not given that.
No, that he is saying you have given.
Page 17, my lord, on account.
He is saying
Last,
he has given.
my page 17,
Let's
my lord. 17, my lord. Last, my lord, 120 20 January 2026 stands for 3 lakhs, my lord.
3 lakhs he has
3
done
lakhs.
that.
Also, that they should give another proposal if they want to do
He
that
has
one-time
given the
settlement.
proposal, he has sent money.
Not
Bank
sent-
manager keeps it at the pillow.
Not like this.
Huh.
They have accepted.
What else?
That is, they have given a simple proposal. They have not given any money to the bank, let's say. That is there. And at
If
least,
they give a proposal,
once again, if they want to give a proposal with money,
you give the proposal now.
My lord.
You treat this 3 lakh rupees as the proposal amount
My lord.
and take a decision on that proposal.
lots,
We leave all contentions open
lots.
and till you take a decision on that, no troubling of the borrower.
Yes, yes. No,
All right.
yeah.
Oh, good. Petition prayer by the borrower is coined as under. Next paragraph. Learned counsel for the petitioner vehemently argues, holding a check in his hand, which is appreciable, that 2 loans he had taken, one in January 2021 in a sum of rupees 15 lakh, another in December 2021 in a sum of rupees 9 lakh. First of all, he tells that as of now, about 31 lakh is due, and that he is ready and willing to go for OTS facility. Semicolon. A sum of rupees 3 lakh in advance is paid by way of the premium for OTS application on 26 January,
21, 25 January.
25 January,
20 January. My lord.
20th January 2026. And despite that, the bank is not considering the same. First off. Next paragraph. Learned senior panel counsel volunteering appearance on instruction of the OPs opposes the petition, contending that in loan transactions, the RIT court has no business to interfere. First off. Having so contended, now very fairly, he submits that if the petitioner makes a comprehensive representation for one-time settlement, there would be no difficulty for considering the same in accordance with the policy guidelines of the RBI. First off, he also tells us that earlier, the OTS facility was provided in a sum of rupees 14.76 lakh. And now also, the OTS offer would be fairly considered. First off, this is really appreciable. First off, next time, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to offer OTS in the prescribed form with all necessary requisites, and that the sum of rupees 3 lakh paid in on 20th January 2026 would be treated as the premium for the same. First off, bank to take a call on the subject offer if made within 2 weeks, in accordance with the policy guidelines obtaining in the realm. First off, till such a decision is taken, no coercive measures should be adopted for recovery of the funds. First, no costs. Okay. Yes.
May I play one thing?
Yeah.
Some time period being bank mentioned.
Why do you believe? Till they take a call, no coercive proceeding.
In notice.
Did not follow the order probably.
For you 2 weeks. For bank, we cannot pressurize them. They have many commercial elements, many things where a host of things will enter. It's a fray of contract which court cannot interfere. Yes.
That's it. My prayer is to, my name must be reflected.
Name to be.
That I have given the
Yes.
Pauline.
Ah,
May I please, Your Lord?
yes.
My Lord, here, my Lord, the notice,
Page number 9,
my Lord, item number 8, my Lord.
8. Okay.
My Lord, here the bank called upon me to give the physical possession of the property
Yeah.
under annexure 10, my Lord.
What is the loan amount? When the loan was taken, nature of loan
My
installment.
Lord, my Lord, it is a, my Lord,
Business.
MSME loan.
Business loan.
Yes, my Lord, 12 lakhs, 3,700, my Lord, 12 lakhs, for 12 lakhs, my
Well,
Lord.
about
12
when
lakhs,
it was?
my Lord, it was in 2017, my Lord.
2017.
My Lord.
What's the rate of interest?
My Lord, 10%, 10.5%. At the rate of 10.45% per annum.
Ah.
Loan was taken on 19/12/2017. My Lord, thereafter I have paid around 11 lakhs of money, rupees, my Lord.
When it was paid?
My Lord, on over the period, my Lord. And ultimately my account was declared as NPA.
10.45.
My Lord, my account was declared as NPA on 5/3/2021 and notice was issued under section 13(2) on 9/8/2024 intimating that
32.
my Lord,
98.
24.
24.
What is the amount mentioned?
My Lord, the amount was mentioned 12 lakhs 3,797.
12 lakh 3,000.
3,797 as on 8/8/2024.
8/8/20. You said 13 to notice was 9/8/21.
9/8/24
24, my Lord.
24.
at page 9, my Lord.
12 lakh.
Now, my Lord, what has happened thereafter? I have deposited more than 8 lakhs 50,000, my Lord.
8.5. You have paid.
My Lord.
Totally how much you have?
My Lord, as per their statement, my Lord, I have deposited 5,65,000.
Credited.
I have paid, deposited.
Why do you say deposited? You have credited.
My Lord, credited. My Lord, credited.
Yeah.
Credited 5,65,000.
Totally.
My Lord. As on, my Lord, no, my Lord. After notice, 13(4) notice.
To 13 for notice.
Notice, my
When
Lord.
you said 8.5, you
My Lord, I have deposited another 1 lakh that has not been shown in the, my Lord, the account statement given to me.
totally how much you
My Lord, now I am, as per their, my Lord, statement, I am due to pay, my Lord, 4,99,251.
5 lakh.
My Lord, I am offering them.
You are paying 5 lakh now.
Yes, my Lord, I am offering them, but
Lord,
they are.
But not since we haven't received any copy of the writ petition. And since the bank has just opened, I haven't got what is the balance payment which is due to be paid, my Lord.
What action they want to take now?
My Lord, they want to take physical possession of my property,
Don't take it.
My Lord,
residential property. I am ready to deposit.
Have you entered KVA?
Alternate remedy, they have already moved section
Have you entered
17.
KVA?
My Lords, my Lords.
Have you-
No, I have instruction to appear, my Lord.
No, that is no KVA.
I understand, my Lord.
Let's see, we will issue notice.
Keep it to day after tomorrow. I'll take
No
instruction.
coercive action. See, the kind bank cannot act as Shakespeare's.
My Lord, since they have already moved under section 17 to DRT, SA 121 of 2025 is
That's all
pending.
right.
My Lord, but
Even
keep it
then
to day
it's
after.
not covered. We are saying, see the kind of the way the bank is treating his MSME. He has paid more than 8.5 lakh according to him.
According to him, my
According
Lords.
to him. Now, what is the pay? 5 lakh.
My Lords, there is an email annexed to the writ petition because I was just going through in the soft file. It was showing an outstanding of more than 10 lakhs. Just
No,
check.
my Lord, that is a dispute for which
You pay 5 lakhs now immediately.
Yes, my lord. I'll
Pay
deposit.
immediately 5 lakhs.
My lord.
Then we will come to you after you want money.
My lords,
Money back.
if he's paying
That
the
disputed amount, your
outstanding
lordship.
dues, but my lords may keep it to an early date.
No, nothing like that. It's a rate call. Can we send them back saying that
No, my lords may keep it
some
to an early
theories?
date.
Huh?
I kindly fix an early date so that I can give a
Can
response.
come- That we'll do. That will. Petitioner and MSME borrower is grieving before the court against coercive loan recovery by way of amount. Now public auction of the security property. Public auction of
public
possession.
auction.
My lords.
Now intended
Physical position.
intended taking of possession of the security property. First, counsel for the petitioner submits loan is of the year 2017, semicolon. Interest is at the rate of rupees 10.45 per annum, semicolon. Loan was declared NPA, account was declared NPA on 5/3/2021, semicolon. Section 13(2) notice was issued on 9/8/2024 for an outstanding loan of rupees 12,03,797. First, he also tells that his client has paid more than rupees 8.5 lakh and that the remainder is roughly about 5 lakh rupees.
As per their statement, I
think we have said that.
4,99,251.
A little less than rupees 5 lakh. First time. He highlights the account statement.
Page
A
32.
copy whereof avails at annexure.
My lord, annexure, my lord. 8, page 32D.
All right. First. Learned panel counsel appearing for the OPs opposes the petition, contending that the outstanding is much more than what is asserted by petitioner's counsel, and that she would come up with all credentials and the figures if a reasonable time is granted. First of all, this sounds to be fair. Well, first, however, till the bank comes back with her counsel, the petitioner need not have the threat of losing possession of the subject property, since he has already shown bona fide. Although, albeit with some arguable lacunae. First off, next one, in the above circumstances, the bank is restrained from, OPs are restrained from any further coercive action pursuant to, what is that notice, 14?
My lord, that is 14.
13-4 notice.
13-4 notice.
Well, it's section 14.
Dated section 14.
14 months.
What have you done? Restrained from
Dated 24.
processing further recovery action by way of taking possession or otherwise of the subject property. If petitioner pays to the bank, account, the subject loan account, rupees 5 lakh
Outstanding.
within 1 week.
2 weeks, man.
Why 2 weeks?
My lord, value.
Within 10 days. Within 2 weeks. As at that. Rupees 2.5 lakh within 1 week. And the like sum in the next, within 1 week next following, failing which petition runs the risk of dismissal.
obliged.
Ordered
My-
accordingly by way of interim protection.
My lord, it's a copy of
And
the,
IAS is hold on. Give copy to her.
My lord,
Take
In
the
course of the
name
day.
Madam also.
in course of the day.
Ah. You print that order.
My lord,
After,
if-
they inform that they have given the copy, not otherwise. Oh.
this,
My lord.
my lord has fixed any date for my lords?
Not 3 weeks,
3 weeks?
2 weeks.
2 weeks.
All right.
My lords, I can come back 3 days.
3. No, it's not. We need not haste. Hasty justice is also bad justice. Yes.
Obliged.
My lord, may I please your lordship? Here, my lord, Annexure 10 is the sale notice by the opposite party bank, my lord. The notice was given on February 3rd,
Ah.
fixing the date of auction to 20th February for sale of my
February of which
residential
year?
2026
21.
within 17 days,
It's not one, all everything.
which is
23 matter.
my lord,
Serial number 10.
9, my lord,
9.
9.
Yes.
My lord, here the auction notice under Annexure 10 is under challenge, my lord. The bank has issued notice by
Loan
email.
is of which year?
My lord,
Loan.
my lord,
Nature of loan,
my lord,
year,
my lord,
and EMI value, interest rate,
my
how
lord.
many paid, how many
My
not
lord,
paid.
my lord. My lord, the loan was sanctioned on 28/3/2022, a house building loan for an amount of rupees.
Housing loan,
Housing loan, my lord. 25,20,172.
20.
25 lakhs, 20,172 with EMI of 241 month
241 EMI.
EMI.
That is, EMI value is how much?
My lord, it is there are another loan of 92,000, top up home loan, both clubbed together and EMI is 23,000. EMI of rupees 23,000, my lord.
Monthly.
Monthly, my lord.
Yes.
23,818,
Over 24.
my lord.
Yes.
My lord, there is a default for EMI for the month of from September, my lord, 2000, September 2025.
September.
August or September, my lord. So there is a default of EMI of, my lord, 4 to 5 months, my lord.
Yeah.
Earlier I have filed the writ application. This honorable court was pleased to direct the bank to consider my application for OTS, my lord. I have given 2 options, my lord. I am ready to clear the arrear EMI.
Yes, sir.
And I may be permitted to arrear EMI. I may be permitted to pay the regular EMI. But that was, my lord, even though that was mentioned in his letter, reply letter, but they have not accepted. If your lordship looks at the, my lord,
See what he says. We have understood your case.
my lord.
What he says, that is what the bank says.
My lord, here, my lord, the status today, morning I have received. In the meantime, the auction is confirmed.
Why confirm? He
Confirmed.
was ready and willing to make the payment.
10% has been deposited.
Yes.
This auction is conducted and it is confirmed in favor of the auction purchaser for 41,60,000.
41,60,000. No, he said it was a housing loan.
My
He was repaying it in terms of the installment.
No, that is not correct. Your lordship, allow me a day. I can come up with the entire statement account because it is a NPA
Yeah.
in 2023.
At the request of learned panel counsel appearing for the respondent. All right, you bring your objection statement in the meanwhile. Counter you file in the registry in the counter. Okay.
My lord, sale shall not be confirmed.
What it is already, he says it. Is it confirmed?
It is 10% we deposited.
We are asking you, is it confirmed?
Sales certificate not issued, but 10% has been deposited.
Better list to right now. Recall that order. The housing loanee is the petitioner against the coercive action of recovery, which has already resulted into auctioning of the security property. First of all. counsel for the petitioner submits that because of some difficulty, some installments have remained unpaid, and that he is ready and willing to make the same good now. First off, he also agrees to pay some solatium to the auction buyer as well, which is the provision in CPC, which provides for payment of solatium. Order 21, Rule 97. Give the CPC to him. Read. Which judgment said Order 21, Rule 97 should be applicable to the bank loans also? You are a bank lawyer. Without all these examinations, you are empaneled in the bank. How many years you have been the bank lawyer?
20 years almost.
20 years.
2006.
20 years you have been the bank lawyer, and you do not know the solution payable to the auction buyer.
I'm sorry, I'll back to comment to them.
Anyway, take that. What you have written? He is also agreeable to pay the solatium on the lines of Order 21, Rule 97. Is it 97?
Yeah, yes.
97. Okay.
You go through 97.
Exactly. Is obstruct clause application.
Obstruction.
Is it 89? 89, 91. It must be. Can anybody good in CPC mention this? Mr. Mishra, which is the provision in CPC which provides for payment of solatium to the auction buyer when the auction is set aside? Order 21 rule? 89, 90, 91.
The 1991 Order 21 Rule 97 you
No, 97 is obstruct clause applicable. It cannot be this.
97, 99 both deals with that. But so far as the auction
89, 90, 91 is this what my
yes,
sir used to say.
that is 85 actually. Order 21 Rule 85 regarding the full payment to be made.
18, he's saying. 89 it is. 89, 90, 91. Three provisions. Madras High Court, Rajmanar's judgment.
That deals with the auction procedure. That's all.
Okay. One, sir. Yes. What you have written? Rule 89, 90, 91. Rules 89, 90, 91.
89, 90, 91.
That's what. What's that?
My lord, I may be one.
Solatium you should pay.
My lord, one
I
submission.
subject to what he will say. We do not know.
My lord, that is correct, my lord. Your lordship's correct. But if there is irregularity or illegality in conducting the auction, then the borrower is not liable to pay.
No, he is liable. Then I'll say, Justice Rajamanar of Madras High Court.
One more
Well,
aspect, Lordship will consider 13.8 is a bar now.
Let us see. Let us see. After all, you want money. Yes. First.
90, my lord, is there.
Next one. Having heard learned counsel for the petitioner and learned counsel for the bank for a short while, we are of the considered opinion that the auction that has already been effected shall not be confirmed, if already not confirmed, by the OP bank till the next date of hearing. First of all, IA is disposed of. Call this matter week after next. In the meanwhile, it is open to the OPs to file their objection. Reply.
Oblige.
Yes. Bank counsel, bank advocates, we want to tell something. We have been observing where property is worth very higher value or being auctioned for songs for a very, very cheap rates. We presume that it cannot happen unless some unscrupulous bank lawyers or big bank officials are involved in that. We have been coming across such cases where borrowers are put to greatest injustice by selling the property. Already they are in distress and you make distress sale of their properties. That may not be the correct approach. Anyway, we are waiting for some good case where we will open up our dagger. Yes. Okay. Next. Not made to love one thing of skin for your pity. Come to tell you not to do. Office requirement to be complied with within 1 week. Filling with petition stands rejected on its own. Post next week. Filling with petition runs the risk of rejection on that ground alone. First of all, call next week. Yes. In just 2 weeks. Just 2 weeks. Call after 2 weeks.
May please, Your Honor. In this case, my Lord, the writ application was filed. There is a delay of 31 days, and filed the medical prescription. Medical prescription relating to his treatment at government.
Item 11. 10. 11. 11 you want time?
No, ma'am.
10 you are mentioning.
Yes, sir.
Okay. All right. We'll make it 2 weeks.
No, ma'am.
Not for you. For complying with the requirement.
Item 10.
Item 10, instead of dismissing, we are giving him 2 more weeks to complete. Second set he has to file.
10 noting is the second copy, not filed.
That yes.
So yours is item 11.
Non for the petitioner in
Okay.
item 10.
All right. Okay. Yes, sir.
11. I'm for 11, my Lord. In this case, my Lord, the writ application was filed. There is a delay of 31 days, my Lord. I have filed the medical prescription relating to the treatment at the government hospital, my Lord.
Petition appellant's statement or your treatment?
No, appellant's statement, my Lord.
Appellant's statement.
Yes, my Lord.
What had happened to him?
My Lord,
What's the delay?
delay is 31 days.
Condone the delay.
Lord, I have lodged a caveat. The copy has not been served upon me.
But all that copy, that is for interim order. This condoning delay is not an interim order.
Limitation.
Limitation. Generally, we have standing call.
No intimation has been given to me.
There is a noting caveat number 216 of
Anyway, no, let us, we feel the delay to be cut. It's a 30-minute delay.
Your also may condone the delay, but I am appearing for respondent number 4. I have lost
Only respondent number 4.
Caveat number
Other respondents are served now.
Yes, ma'am.
These are all post-notice matters.
Yes, ma'am.
Other respondents are served.
My Lord, sir.
No, these are my Lord, fresh matter, it is for orders.
The fresh matter.
First time.
Fresh matter, it is for orders.
After it is coming first time, even 23 matter is coming first time.
This is my 25, it is item 11. my Lord.
The first matter, 23. What people will think about the judges? Anyway, sir, you give copy.
Yes, ma'am.
You give copy.
Yes, ma'am.
Notice has to go.
Yes, ma'am.
And after service of notice, we can condone, not before that.
Yes, ma'am.
What is the matter on merits?
My Lord, merits is, my Lords, the dispute crop up of correction of the ROR after 40 years, my Lords. The parties as the 2 branches of the
Is there any limitation for correction of ROR?
No, man. No, that is 1 year, my Lords.
For correction?
Yes, ma'am.
Which is section? Which law? Take out ILR 1985 Karnataka
15B of service.
1058, 1059.
No, 15B, you are speaking about revision.
Yes, ma'am.
There's no revision.
He's got, he has, after 40 years, he has directly filed a revision for correction of ROR.
Is there any provision which prescribes limitation for revision?
There are
You just look into this judgment. ILR 1985 Karnataka, page 1058 or 1059 by Justice Rama Joyce. division bench, affirmed by the Supreme Court,
Yes, ma'am.
where no limitation is prescribed, then the question of limitation would not figure, although latches may, which has to be adjudged on the basis of period of appeal prescribed by law.
Yes.
Just look into that judgment
Yes.
and come back.
Yes.
That gives you the whole lot of entire jurisprudence relating to the revisions in revenue matters and limitation for filing the revision.
Yes.
It is Sriman Niranjana Murugarajendra Swamigal versus Special Deputy Commissioner. Very famous judgment it is. Yes.
In this case, madam, I filed a petition for stay matters. Only till final order, my lords, the amount may not be disbursed.
Is there, na?
Yes, ma'am.
You give copy.
Yes, ma'am. I'll serve the copy.
Only then we'll consider an interim prayer because he has already entered KVA.
Only thing is that the amount will be disbursed, my lords.
We
Only
do
to
not
disburse
know.
the amount, not to disburse.
To whom it should be dispersed?
To him, my lords, by the authority. Not to disburse the amount till
Have
final.
you taken the money now?
So it has been, since it is arising out of a pool bearing acquisition. So the matter is pending for this apex court. Apex court remitted the matter back to this honorable court. It is pending before a honorable division bench.
In another matter?
Regarding the
Which is that W?
that WPC
Is
number.
it before us or before another bench?
Before court number 20.
Then we'll say let this matter also the registry consider to post it before the other court. Issue emergent
But
notice.
this is my writ appeal, ma'am.
That's all. It will be before the another bench because they are correlated with each other. That's the reason. What you written? Issue emergent notice. First off, learned counsel who? Your senior advocate. Who is the advocate on record?
That's all.
Srimati so and so has entered KVA for the OFI number. Response number 4. Response number 4. First off, both the sides submit that a connected case in WP number.
C. 15522.
15522 of 2025 is pending consideration on remand by the apex court to a coordinate bench of this court, and therefore this case also can be both the cases can be heard together. First, next one, registry to explore the possibility of agreeing with the proposal of the bar after taking necessary orders at the hands of Honorable the Chief Justice immediately. First, we have noted that whatever amount arguably payable in respect of particular piece of land has not yet been drawn by the caveator till date. First, yes, we have made it this way. All right, we'll come back within a couple of seconds. 12.
My lord, on behalf of Advocate S.S. Krishna, I am praying for a short argument.
2 weeks, sir. At the request of the. No, in the meanwhile, comply with the order. In the meanwhile, office order requirement to be complied with. Failing which appeal may be dismissed on that ground. Yes. Yes, sir.
I am
Madam Jena.
appealing for the petitioner. Your lordship may kindly turn to your lordship's order dated 5/2.
By 226.
Yes. 5/2/26, page 11.
Marginal interference.
Page 11 of the IA. Page 11.
I copy has not been solved.
Please give copy.
Right now, I will give your lordship may quickly to after lunch.
Will it be all right?
Yes, because there is nothing, my lord, there is nothing. They have.
You give copy.
Yes.
Let him look into.
Yes.
Then depending upon his requirement, we.
It is there.
Instruction from the bank.
There is no.
My lord was pleased to dispose of with certain direction. That has not been complied, that I have heard.
But
That has not been complied and this petition has come.
my lord,
My lord, order was so specific. Within 15th, we will communicate. Within 20th, he agreed to pay everything. He has not paid a single part.
You look into that.
yeah,
Then you can come out with your answer. At 2 o'clock?
at two.
Ah,
Problems.
pass over. Yes.
Item number 14.
Ah,
I'm the wife of the borrower.
wife of the borrower.
Yes, sir. In the year 2000.
You.
I'm a borrower from the OSFC.
OSFC.
State Financial Corporation.
Yeah.
My husband got a loan in 2000, year 2000.
Yes.
2 loans, 2 term loans and 2 NEF loans, you know. Yes,
You are not, there is no privity of contract.
no, absolutely.
Then how can you maintain the petitions?
Sure. In the meanwhile, my husband has died.
Right.
Right. Then he took a loan, total amount was 21,70,000 in the year 2000. In the meanwhile, I have repaid a maculation. And the OTS could not be fructified because
Slowly you go. It was 21 lakh in
20,000.
21,70,000 I took loan in the year 2000, your Lordship.
2000.
Husband took loan in 2000.
Took loan. In the meanwhile, in the year 2004, I diagnosed with
When
cancer.
marriage took place.
I do not know. I have to take that section.
Okay.
In 2004, I was diagnosed with cancer. For that, my husband was busy with the treatment and everything. There was a default. So due to that default, he could not pay. And in the meanwhile, I paid. My husband paid something, and an OTS proposal was given to them. That application is on record, which was accepted by the OSFC Lordship. There was a certain condition he could not fulfill but in the meanwhile, he paid the almost entire the principal amount. However, the OTS could not be fulfilled, your Lordship. In the year 2000, they revised the entire installment period, your Lordship, which he was trying to pay. I again diagnosed with cancer. That was a recurring process, as you know. I again diagnosed with cancer and we could not fulfill to that.
What kind of cancer it was?
I'll just
Cancer,
Yes.
82 types of cancers are just many are innocuous.
yes.
Yes.
I have
Which what
at annexure 16, I have given all the medical reports.
and what was the stage?
Third stage, your Lordship.
What stage?
Third stage. And the entire treatment was taking place in Mumbai. That is why. Your Lordship, in the meanwhile, in 2021, my husband died.
2021.
2021, my husband died in COVID. Your Lordship. Now I'm facing the recovery proceeding by the OSFC. Your Lordship. Your Lordship, kindly see.
What kind of recovery proceeding?
Your Lordship, because there are 2 properties as mortgage with the OSFC for which I have taken. My husband has taken a loan. Now they are threatening me.
Recovery, what kind of? Mr. What can issue them anything?
My learning sister, in fact, it is said that the matter should go to the mediation. I have no objection to the mediation, but it is the 5th round of litigation.
Anyway,
I'll just
Because
one document.
because of the cancer, my learned sister is saying that it's suffering from cancer, all these things. Account position is very, very derogatory. Lordship kindly see the account position is more than 4 crores paragraph 24 of my counter be that as it may. Why not in that? Since my learned sister is saying that it could mediation, let us see. Let us see if it will compromise, then I know that.
So the principal amount is only 16 lakh 74.
Maybe, but
There is no dam dupat applicable to statutory loans. Is it that?
That is how I was saying if it can be referred to mediation.
what happened, my lord? OTS rejected, again OTS, again reapplication, dismissed. So I am not in that. So
Housing loan or business loan?
It's a business loan.
Commercial.
Yes.
if at all it's compromise, I will see that it will be done something.
Heard Learned Counsel Srimati so appearing for the petitioner Loni and the petitioner who happens to be the widow of DC Loni.
She is the petition number 2. Petition number 1 is the proprietorship form.
Which number 1 is?
Proprietorship form against whom that loan was taken. Yes.
First up, she happens to be the proprietrix of petitioner number 2.
No,
Petitioner
1.
First petition. Entity. First petitioner entity. First up. It's not a partnership firm.
It's not a partnership.
Therefore, it's an entity.
It's an entity.
First, she mentions about the ordeals she underwent because of death of husband and also the carcinogenous issues. First off, she seeks referring of the matter for mediation under section 89 of the CPC 1908. First off, next part. Learned senior advocate Shri so-and-so appearing for
BK Das, Vijay Kumar.
appearing for representing the
The state finance.
OSFC, having opposed the petition, now very fairly agrees for the proposal of proposal for mediation. First of all, we are also seeing some elements of mediability, and therefore of the opinion or of the opinion that mediation is worth undertaking. First, next one. In the above circumstances, matter stands referred to state mediation. We have a High Court, a state mediation center. Mediation center. First up, parties shall appear before the member secretary of the center. At what date you will be appearing?
Any day next week.
Next week. On whichever date you test on a particular date.
4 o'clock.
On 9th of March at
4 o'clock.
4 o'clock.
4 o'clock.
At 3 p.m. At 3 p.m. before the secretary and take further instructions at his hands. First, the secretary is requested to cause accomplishment of mediation at the drain hand within an outer limit of 8 weeks.
8 weeks.
Reckoned from this date.
Yes.
Okay. Till then, what they are doing?
So they may not take status quo. No coercive action.
Will not take any action.
Next paragraph. In the above circumstances, all coercive proceedings for recovery would stand at a bay.
He used the amount. He used the amount with the public money. That's why it was there. Anyway, it is because of the predicament. I understand.
So many things. I see in life that P.B. Shelley, a melancholy poet.
That's good. I would not have.
It is said, I fall on the thorns of life, I bleed.
That's good.
Sometimes thorns come and pierce us is one thing. The other times we voluntarily fall on them and we bleed. There are such cases in that angle. Very beautifully written. There is one poem by Vajpayee. He says, in the life, the horns did not pierce, but what pierced are the flowers. Very poetic, Prime Minister.
Because of the 4 to 5 data applications are there, in fact, it didn't get in the anyway, my lord.
Anyway, just looking. And use your best office also. And that will be a work of Punya. Is that Punya word? In your
Punya.
Yes.
Punya. It's Punya.
Much of
Next.
My lord, due to some personal defense of Lord and DSCI, my lord, the letter may be taken up tomorrow, my lord.
Tomorrow?
Tomorrow.
Tomorrow will take that.
Tomorrow my friend will not be there. Next week, my lord.
Whichever date you want.
But coming Monday, my lord. 23rd. Sorry. No, sorry. 5th or 6th.
5th or 6th?
Yeah.
I'll be 6th.
Much
At the request of the appearing for science.
Milords, I appear online in this matter.
Milords, item 16, I'm here for respondent number 4, the contesting respondent.
Milords, I appear online, Milords, for petitioner, Milords. Milords, I'm led by Mr. Sanjay Sen. Yeah, he's in some difficulty, Milords. Milords, may put it in April, any date, Milords. April, Milords.
We had a very song, April, come again. We had such a song during our the primary school.
Milords,
Why April? Why not? Why should not you march to March?
Milords, unfortunately, his calendar. Anyways, Milords, his calendar doesn't allow. But Milords, if wishes to plead, wishes to places any day in March, I'll have somebody appear. March will be difficult.
Your friend is saying April is the good time.
It's fine, my lords.
April, spring will come.
Yes, Milords.
It's early here.
We have no objection to the request.
No spring.
No spring at all. Yes. All this matter, the first week of April, as requested by the net counsel appearing for the petitioner, and rarely conceded to by the other side.
My lords, any specific date in the
First week, we do not know which bench.
Obliged, Milords, obliged.
Bench we cannot.
Obliged.
Yes. Regular date we cannot.
My lord, here.
Yes. This matter, before my learned begins, I am for the contestant, I am for one of the petitioners in the writ petition. My petition was allowed and their writ petition was dismissed. But here, I have filed an application that's an IA 3758 of 25, where I have questioned the locus of the present appellant to maintain this. And there is one application which they have also filed, to which that is IA number 579 of 26. I had somehow missed it. I just saw it in my file when I was studying the brief yesterday, to which I need to file an objection.
Yes. My lord, here the locus is being challenged.
He wants to file objection.
My lord, what they are doing, my lord, I have given the photographs. Let them not make any construction because
question that is not in my hands. I have leased it out. I have put it on affidavit.
Construction. If it takes place, if you win, you will get
No. It's not a question of property. They are blocking the parking area.
No,
they are making it problems, converting the problems.
By the learned single judge.
Mr. Mukherjee, he is saying something which you are denying.
Absolutely.
We will record. You are saying
yes,
they are blocking by construction. He is saying that is not true. We will record that.
Yes.
Learned counsel appearing for?
My lord, I am for the appellant in 2 appeals.
Appellant. And same appellant.
No, the same appellants, but one addition is there.
The appellant is appeals. It submits that the answering respondent is continuing with the construction, that would
Change the nature and character.
block, no, you
Block-
entry point.
Block the, block the parking area and other empty spaces.
area.
Yeah,
No, no, other empty spaces, what is other
What is
empty
parking
spaces?
area? What is
Parking area, you are concerned with parking area.
Yes.
Parking, first up. Learned senior advocate, Mr. Mukherjee, representing OP number
Five, opposite party number 5.
submits that the said submission is not true. First up.
There is no interference with the apartment dwellers or their parking.
there is
He
interference.
further assures,
Yes.
he further assures that there shall be no interference with the parking lot. And he said one more.
Residence area.
The entrance and exit of the apartment dwellers.
So ingress and egress to the apartment.
Apartment dwellers, yes.
First. This assurance should suffice in our considered opinion. First. All these matters after 3 weeks.
Your Lordship, if Your Lordship, they don't want to file an objection to my miscase, that can be taken up because I am questioning their locus.
Well, they have not served me a copy. What objection I'll file?
You can ask Mr. Mukherjee. He will give you half a dozen copies of
No, my senior is designated. I cannot ask him a copy. I can only request. Yes.
Dissenting counsel officer. He will give copy and coffee, both.
Yes, he gives.
He does.
My lord, I only say a lordship may fix it because it is a fresh admission. The appeal has not been admitted.
You are protected. I'll call this matter after 6 weeks. Yes.
3 weeks, Your Lordship?
No, 6 weeks. Yeah, yeah. Because you are protected.
Grateful.
Yes, 18.
In item 18, I am for the appellate.
Mr. Yes, they have done. No problem. Yes.
Item
Yes,
18,
you
I
can
am-
dispose of. In terms of this. The IA numbers 2252 of 2025. Is accordingly disposed of. First up, IA number 579 of 26 for early hearing is also disposed of. Because 6 weeks you have said. Yeah. Yes.
Lordships, in item 18, I am appearing for the appellant.
Yeah.
Your Lordships will see the last order. Your Lordships.
Order of 25. Applications for condonation of delay in preferring the instant that is beyond the period of limitation. How many days of delay?
No. Lordships, item 18.
Huh?
Item 18, 15, 10, 25, no?
Yes.
18.
No, 5/2/2026.
Give the order. 10, 25.
5
Yes, to.
5/2/2026.
Is there such an order? Yes.
The last order.
Yes.
Order number 4.
Order number. Reflect fitness.
If I may read the order.
Do you want to face it, no? They go to 5-2 order.
It is there. See, you come to 1510 and then you roll it.
Go to 5-2-26. We got it. It already filed the affidavit. File the affidavit on a open to the opponent to file the rejoinder, if any. All this
Respondent.
23-2.
Yes. So your Lordships.
So, Lord, respond number 3, 4, and 5. Our affidavit is ready. We will be filing today.
I've been served with a copy
And
of the counter.
2 has already filed.
2 and 7 has.
I'm appealing for 2, Lord. I'm appealing for 2, Lord. I'm online because of my health. Lord, I've already filed, Lord.
Your file.
Yes.
Yes, sir.
And
I'm appealing. I've filed.
Yes.
If I may be permitted to file a rejoinder, looking at all the.
He wants a short accommodation. Can we grant that?
Any short time, your lordship may grant for his order. There is no interim order, so there is no difficulties.
For replies.
We are filing the
Sometimes
update today also.
Ah.
We are filing the update today.
2 weeks time, because 4 replies are there.
Huh?
Yes,
Four replies.
Or he is not constructing 4 buildings.
It's a difference.
Four,
Yes,
yeah.
your lordship. 2 weeks time.
2 weeks?
2 weeks.
3 weeks will be.
Yes.
Respondent number 6, Tahsildar also filed an
We
affidavit.
have received all the replies. Yes.
While order dated 5/2/2026, we had said as under. Next paragraph. In terms of the above order, should not put paragraph, big paragraph, but don't number the outcome because it's anything more. In terms of the above order, respondent numbers, we have filed the respondent number 6. 1 second. Others have filed.
3, 4, 5.
Yes, my lord.
We are
Everybody,
filing
all the
8 also. Opposite party 8 also has filed, my lord. That's recorded in the last order.
2 and 7 have already filed.
7, 8.
8 also. 8 also. 8 as well.
All parties probably have filed. 2, 7, sir, I am representing, I have filed, sir. 2 and 7. I have
Today.
2, 3, 4.
3, 4.
3, 4, 5. 3, 4, 5, and 6 want to file the affidavit.
Already filed 6.
6 or 5. 5 today. Then 6, 3 has order. 2, 6, 7, 8 have filed. What? First. The counsel appearing for the appellant submits that his client wants to file a reply to that.
Rejoinder
to that capital. And therefore a short accommodation be granted. First, all other advocates agree with this problem. First, call this matter after 3 weeks. Okay.
What date can
My lord, may I request if it could be on the 23rd of March, my lord? 23rd if it's not inconvenient.
Call this matter on 23.
Lordship, can it be 24th with
24/3. He is saying 24/3. Is it all right?
But I would prefer 23rd if my learned friend can accommodate me.
counsel in this matter is not available on 23rd, your lordship.
It is not available.
On 23rd, that is the difficulty.
Sir, you suggest one more date, whichever you want.
Your lordship may have it on the 25th then, 25th.
Is it all right?
Yes.
25th of so. This date is pulled down by the learned advocate from the calendar. Okay.
grateful, sir.
Yes, Mr. Sir.
There is a departure from the normal procedure. Here the bank has filed the return.
Bank has filed the writ petition, writ appeal, writ petition.
Normally, actually, the noni files application for lordship. The bank has filed rejection of an application under section 14 of the Surface Act.
By CJM or collector? By CJM.
What has happened here, there is a loan of about more than 19 crores. In due passage of time, some amount has been repaid and there was outstanding of 9.10 crores, something like that. Then the 13th notice was issued after the loan was made NPA. On 13th notice, a response came from the other side that I have given number of landed properties as mortgage, equitable mortgage. Out of those properties, if you allow me to sell one item of property, then I can deposit the entire sale amount and liquidate the loan amount. The young lady was there as the bank manager. She said that is good, the entire amount will be repaid. Then she agreed to that proposal and said that all right, you can sell. But the loan mortgage was a composite mortgage, like 5 items of property in one mortgage deed. So he requested you execute
composite mortgage.
Composite.
Anomalous mortgage is known to law. Yes.
Right.
But composite mortgage is unknown to law.
Composite in the sense 5 items of
several properties are involved in one mortgage.
Right. So therefore, the bank said, already you do it. He said, unless you make a reconveyance deed, release those properties, I cannot sell. Mortgage property cannot be sold.
Why?
Good faith.
Why cannot be sold?
Because it is mortgaged.
Well,
here is the tax.
It shall not be.
It cannot be. The registration cannot be done.
that we do not understand this elementary position of law. Section 5 of the Transfer of Property Act says even mortgage, as interpreted by various courts in the country, says even mortgage property can be subject to sale, because what you will be selling is equity of redemption. Nothing beyond that. Unless the mortgage deed itself prescribe that there shall be no alienation of the property.
That was the understanding of the bank and the person concerned, and he requested
such a condition.
Reconveyance deed. The bank officer.
Condition there.
Was it a condition that he shall not sell the mortgage property?
So I have not seen that document itself. But here actually.
Who appears for the bank?
He is for the bank.
I'm for the bank.
You only for the bank. Okay.
But the bank manager executed a reconveyance deed. After it was executed.
Reconveyance. How reconveyance?
That means that the mortgage was released.
It is not reconveyance.
But they designated it as reconveyance.
That's wrong.
On the basis of that, when the bank said, all right, you.
In fact, Pindra on conveyancing,
right,
volume 2, is this aspect of the matter. The reconveyance question arises only in 2 cases.
Sale.
No. Where it is a conditional mortgage or an English mortgage.
Correct.
If reconveyance is made in the sale deed itself, it is not a reconveyance at all. That's what Mr. Bindra says.
Reconveyance, there must be a condition in the document itself.
That should be. Otherwise, in English,
but that was the long motion and they executed it.
Okay.
As a result of which, the loanee got the benefit releasing of all the mortgage properties. When the bank manager said, you sell one of the item and re-deposit the, re-execute a document in favor of the bank, he didn't respond to it. Then 13-4 notice was issued. In fact, no money has been deposited. I can understand deposit.
How many properties you have, according to you, reconveyed?
All. How many? 4.
All properties.
All properties. That is the only problem.
Then that mortgage stands resolved.
Yes. Right.
Where is your right to come to this court? What action against young lady?
So question arises.
Yes.
That can only be released if a payment has to be made.
Conditional.
Conditional.
But where is that?
No payment has been made. Not a single money has been paid.
No, question is not that. Mullah, in his Transfer of Property Act, has dealt with this aspect of the matter, where he deals under section 54, 54 and 556 of TTP Act 1882, where he says, where you have sold something, reconveyance is nothing but a sale only,
right,
going by your own version. If money is not paid, consideration is not paid, then you are entitled to sue for that consideration. There is such a paragraph.
The sale is itself is void. If no
That how can we decide whether sale is void? How can, because it has to be void for 4 reasons, perhaps 5 reasons. Nudum pactum, because there is no consideration at all. This aspect is dealt with, and it said it is not a case of nudum pactum, because there is an obligation undertaken from the other side. Another is doctrine of coercion, fraud, mistake, undue influence. That's all. Beyond this, our Indian law does not recognize any other equitable ground.
If no consideration has passed,
passing of consideration is one thing. Absence of consideration is another.
Right.
If it is a case of nudum pactum, where no consideration at all, it is null and void. But where it is a case of consideration, but it has not passed.
Right.
Then one judgment just took it to.
Then there's
judgment of Justice
Oka.
Honorable Justice Oka. Perhaps you are referring to that judgment.
So you're saying that judgment.
Where consideration has not passed, sale becomes void.
Yeah, that's right.
I think it is in review now.
Right.
It's in review.
And as a result of which, when 13-4 notice was issued, and we immediately wanted to take possession of the property, symbolic possession was taken, section 14 application was filed. But Your Lordship, was section 14, the purpose of section 14
You
is
said that judgment of
right.
apex court, which is, I thought it's by Justice Oka. Is it by Justice Oka?
Right.
Is it by Justice Oka?
Yes. No, this is regarding consideration. I've got that already. Justice Oka Mallet. Justice Ajay Rastogi and Oka Mallet.
This is put in, this is Justice Abhay Oka. This is put in review now. Just look into. Anyway, just look into. If consideration has not passed, then sale becomes void. Is the version of the application. This one. Who appears for the borrowers? You appear for the borrower. Yes.
The only question, sir, can he say, I have deposited the entire money?
How much money he has deposited?
8.9 lakhs and crores.
How much he has deposited?
So he out of somewhere 18, 19 crores, in due passage of time, he deposited some money. And the balance amount was there.
May I?
It's a public money, Mallet.
Your client is ready to pay the money, or we have to strike down all the entire conveyance, reconveyance, because it is not simple reconveyance.
But sir, whatever my Lord and senior submitted, but the reconveyance deed that speaks the otherwise.
Read that copy. Where is that reconveyance deed?
Page 82 of my counter application.
82.
My Lord. Let's say come to the fourth paragraph. Where is second party mortgage?
Let us see. Entire deed itself.
My Lord.
Deed of reconveyance. Deed of reconveyance. Is constituted under the banking acquisition so and so. It is not constituted. It is governed by perhaps. That's 1971, that R.C. Cooper versus Union. That
Yes. No, let them show that 15 crores, 80 lakhs they have deposited. If they show him for lordship that he has been deposited, I have no case. This was executed in good faith.
He says, whereas the second party mortgagor, as per the said mortgage deeds, has paid the entire loan amount.
Yes. Let him show that he has deposited the money.
This is a registered document, my Lord. This is their own admission that they have issued.
No, that's not the law.
But here it is not contested.
Have you put it in the pocket of the manager? It has to be by transactionality. Any amount more than 15 lakhs has to be by the check account only. Show that.
But here, my Lord, what they have admitted, then 58 of the evidence are confirmed.
No.
Once the admitted fact need not be proved. That is my submission.
That is only one aspect of the truth. That is not the law. Admitted facts. Read section 30 or 31 of the Evidence Act. 31 has to be read with 58. 58 is not an isolation. 58 has to be read along with section 30 or 31. You saw what Professor I.G. Hiregoda used to say when we were in the school, law school. It is that section, I don't remember. Maybe 30 or 31.
So 31-2, I think.
No. Only one section.
Evidence Act.
Smallest section in the Evidence Act. Smallest section in the Evidence Act. Take out that Evidence Act. Which says, admissions are not conclusive evidence. Strangely, the title is like that and the text is like
31.
31.
That's right, 31.
58 has to be read umirally and drop and amirally on Evidence Act. They say, and they have referred to free counsel judgment, English judgment, Ojas judgment. Smith say 58 has to be read along with 31. They are not island provisions. We have to show, if you show that your client has paid, then the question will be different. If you say it amounts to admission of fact, and therefore it need not be, just read that section. Give that section to him. Section 58 says admitted facts need not be proved. That's all. That section 31 says admissions are not conclusive evidence. There is a lot of 1964 Supreme Court.
My lord, I got that. But
show.
Even in that case, my lord, whether for last, because this reconveyance deed was executed way back in December 2023.
You can't use the law as an instrument of fraud.
No, my lord, I am not. My point is that whether they have taken any step to rescind this instrument, my
Need
lord,
not be.
they have not recalled it.
We will declare it now. In our extraordinary jurisdiction, because public money is involved.
Right.
It is not small amount. And you appear to be an businessman.
Right.
You are a businessman. Business is not.
Here, my lord, the issue is whether Section 40, rejection of Section 14 order is valid or not.
That we go, no, it is not confined to that.
This conveyance,
level beyond that.
This conveyance deed is not challenged before any court.
We will tell now. Or you should ask your client whether he wants to pay the money with honor, or we will direct cancellation of the whole deed. The writ court cannot do all that things.
This may allow me to take instruction on that point.
Heard the matter for some time. First off, learned senior advocate Mr. appearing for the bank submits that the very reconveyance deed dated 20 December 2023 is a nullum pactum in view of Apex Court decision in Keval Krishan versus Rajesh Kumar 2022 18 SEC 489. There being no passing of consideration in a huge sum of rupees 15 lakh 80,045. 15 crore 80 lakh 45,000 as mentioned in the said deed. First time.
Not a sale deed, my lord.
Learned
It's not a sale deed,
reconveyance. Learned panel counsel appearing for the bank, relying upon section 58 of the Evidence Act 1872, submits that, erstwhile Evidence Act submits that there is an admission in the deed as to the payment, and therefore nothing contrary can be presumed. First time, we have notified to him the provisions of section 31 of the Act, which says admissions are not conclusive. First time. Next paragraph. At this stage, the net counsel for the panel counsel, no, the net counsel appearing for the borrower, businessman. It's a company.
No, it's a proprietorship firm.
Proprietor.
Rice mill.
For the borrower businessman seeks a short accommodation to come back, as to come back after conferring with his client as to something can be done in the matter. Okay. First one.
But that page 84, page 84, that list of properties are there. But he should not reconvey it, create a third party.
Have you made any application?
In fact, in same application there, Melody first.
Is there IA? 12855. 12855.
Yes.
In the meanwhile, the subject property.
Sorry.
That is the intervener. Who is the intervener?
Sir, intervener is the auction purchaser. Since the property could not be released in his favor, he withdrew. We repaid the entire amount. Affidavit has been filed.
Which is that IA now?
Interim application.
There is no IA to say. One more sentence. We have also told him that law cannot be used as an instrument of fraud. First off, if that at this stage, so and so, in the call after so and so, in the meanwhile, the subject property shall not be alienated nor encumbered in any way. In any way. Okay. Yes.
Except date.
Which date you want?
First week, sir.
Instead of 3 weeks, call this microphone. So 18.3. 18.3. 18.3. In the meanwhile, right, so IAD is put on. Yes. You have to bring that decision of the apex court, Mr. Mishra.
Yes, madam.
Where said the power of the writ court is coextensive with the requirement of doing justice. That judgment you have to bring.
I think 62 Supreme Court is
No,
there.
not 62. Much
62.
later. Much later.
I will find it.
Yes.
Well, in item 20,
Yeah.
there are 3 items. The first item, we have to file counter affidavit, my lord. Your lordship may grant.
You want to file counter?
Yes, my lord.
At the request of learned
Decided in the second case, my lord, counter already been placed.
All 3 are being taken together.
No, it's the covered matter, man. And in the counter they have stated, since there is no order from the Honorable High Court, we are not granting it.
No, this counter will, let us file.
Counter
matter. All the 3 matters can be disposed of but by a common order.
And what is the counter? Read that. You can't take a contrary counter.
No,
So
contrary
file
counter, we cannot take.
My lord,
This
that
matter.
on verification, para 11, my lord, your lordship counter filed by opposite
Law
party number
department.
1 and 2, 1 and 3 in second case.
Yes. Go to second case.
25891.
25891. Para 10, 11, 12, my lordship.
In old general provident from the Orissa rules 1930. Which is the judgment which covers this point?
Anand Das case, my lord. These are related.
You copy.
Yes, ma'am. I'm giving. Does the judgment confirm in the Honorable Supreme Court?
Yes, Mr. Panda, it is completely covered by the judgment. We have already granted similar leave to other people also, wherein your friend, Mr. Mohanty had appeared in that matter. You had appeared in that matter.
Single pension matter, 1/1/25, 2005.
Our judgment.
And recently also, my lord, granted the benefit.
Give that.
Rule 3, sub-rule 4 of the pension rules. The applicability thereof.
My lord, on the same day
2005.
that is 16/8/2005. It is granted because he has approved the court man.
Yes.
Brother, once just looking,
The rules has been amended.
just you have covered everything you have said already. In respect of one set of employees, you have said, in terms of the order of the learned single judge, we are granting all this relief. In respect of other set, you are saying, you have no such order, therefore we are not granting.
That all cases were there.
What is that? Kavita versus, which is that judgment? Kavita?
Yes, sir.
And Krishnamurti, Kavita, 2 judgments, no?
Yes, just to give me.
C. Kavita versus Karnataka. Lalita. That is- you are right.
See, Lalita.
You are right. You are right. Lalita.
Similarly situated person will get the similar order.
Why are you driving all these?
No discriminatory treatment. That will no better, but
Later.
without a counter, if the matter will be disposed of.
This is the counter in one. We have already felt counter in one matter.
In-
And there will be another counter
No.
in a connected matter. No, it cannot be. Take note.
The only aspect that you have to verify is the date of their entry.
That
Date of their entry.
That is as per the records, it will
My
happen.
lord, the register district judgeship for the my lord, he has stated that he has joined it on 16/8/2005, my lord. Prior
Those
to that.
factuals, they will give liberty to them to ascertain the factuals and give that.
Yes, that your lordship.
That we will do.
Kindly.
Yeah. Go to the prayer column.
Counter file in 25891.
The essential grievance of petitioners in these petitions is as to their non-inclusion in the old general provident fund into brackets Orissa rules 1938 and the Orissa Civil Services into bracket Pension Rules 1992. First up. That is how the prayers in the petition have been roughly pointed. Next paragraph. Learned counsel advocates appearing for the petitioners submit that in terms of kindly give that person back that order. You have one more copy. Not this. That order. Order they have issued. Count like out there.
Yes, my lord. I have copy.
Placed reliance on office order dated 3 September 2025 in support of their submission that in terms of a learned single judge's order in WPC 15433 of 2012 between Anand Dash Division coordinate bench order. Anand Dash and others versus State of Odisha and others. Disposed of on? Disposed of by the order dated so and so.
24/4/2013.
24/4/2013, comma. The prayer needs to be accorded to these petitioners, whereas the OPs are taking a stand that the relief was granted to the litigants in the cognate case because of the court order, and that relief cannot be granted to the petitioners herein because they were not parties to the said order. First up, they submit that in view of decision of the apex court in Lalita versus State of the relief granted to a set of employees has to be accorded to the other set similarly circumstanced, derogatory points constituting exceptions. First up. Next paragraph. Learned AGA Mr. Panda appearing for the OPs submits that a short accommodation be granted to file the counter. First up. We do not agree with this because in two of the matters they have already filed the counter, specifically taking the stand that in one of the matters, that is in one of the matters, that is WPC number
25891 of 24.
25891 of 24. They have already filed the counter, specifically stating that those, saying that the petitioners cannot be granted relief in the absence of court order. First up.
Before that, your lordship may kindly see paragraph 5 of that counter affidavit. Para 5 of the counter affidavit filed by 4 and 5, OP number 4 and 5 in the same case where your lordship is referring to. That is 25891.
That is what in para 5.
Yes, para 5.
They were appointed as junior clerk and junior
stenographer, junior stenographer, 16/8/2005 and 10/8/2005.
Yes.
Then, my lord, 1/1/2005 is the cut-off date. If they have appointed a junior stenographer and junior clerk beyond that 1/1/2005,
that will keep it open now.
Yes.
That will
then
keep it open.
this new amendment will be
decided in that case, madam.
That has been decided. Itself is the condition in that case. Then the apex court also.
Yes. There the honorable court has held if a process
cannot be maintained.
Process began prior to 1/1/2005 and the person joined after 1/1/2005.
Up to that date. They are also covered under the old
That is the judgment.
That's what. That's the judgment.
Essence of the judgment.
And the recent order, my lord, which I submitted, my lord, your lordship gone through that.
Yes.
That was the appointment on 16/8/2005.
So what my
order long after the years of cut-off date. So this
Petitioner's case may be considered in the light of the judgment, your lordship, in that.
That's we'll say that.
Good. Say, open line the light of the judge.
Next paragraph. Further, he draws attention of the court to paragraph 5.
Paragraph 5.
4 into 5.
4 and 5.
Of the counter affidavit, stating that those who have been appointed on and after 1/1/2005 are not entitled to seek refuse under the old rules. First off, next paragraph. Having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter, in as much as the very contention which Mr. Panda has now put forth has been treated by the coordinate bench in Ananda Das case. Which is that paragraph, brother? At para 9, which reads as under. Para 9 and 15, 9 and 15, which read as under. 9, 15, 17.
And also 16, man.
Yeah, 17.
16 and 17.
You leave 9. Paragraphs 15, 17,
17
and 18. Which read as. Okay? Just mark it by mother. Hello. Okay? Next point. Learned advocates appearing for the petitioners are right in placing reliance on the office order dated 3 September 2025, which is reproduced in its entirety in view of the significance it has on the issue debated before us. Yes, order. Okay, as it is. Next paragraph. In the above circumstances, these petitions are allowed and relief as has been granted to Anand Das and other litigants in Anand Das case is directed to be accorded to the petitioners herein within an outer limit of 8 weeks.
No scope for our examination.
No scope. Because this has ruled out that also. Yes. However, factuals, liberty is reserved to the opponent to ascertain the fact matter in the light of the judgment in Dash.
Yes, grateful.
In the counter, they have added.
No, that is no. Only Dash answered that also.
Yes.
Okay. In this one, financial implications and yeah. Start. You're printing the solid from the second lesson. Every day it is being printed. Is it adding to some other? Why are you wasting the? Are you adding some cases to it? No, that we don't get, but this cannot do it. Second list need not have printed everything. Or is the waste of time, energy, paper? Yes. Only once. Start. Number one.
My lord, it is a state appeal wherein there is a limitation, my lord. And in the earlier occasion, my lord has directed to make payment of this amount that it has been
paid already. So delay has to be condoned in all matters.
Exactly.
Mr. Rautray?
The only problem is last time, yes, that is no problem.
All these appeals with the state are filed after looking varying periods of delay. An application supported by affidavit in individual cases has been seeking condonation of delay. Personal. Mr. Mohanty Lanedi submits that in terms of our order, the remittance of the delay cost has been made to the respondent employees individually. Personal. This has not been much disputed before us by the other side. Personal. Therefore, applications having been favored, delay stands condoned in terms of the earlier orders. This you write on. You may have to sandwich that somewhere. Yes. Yes, sir.
Well, this is arising out of a common judgment dated 15/9/2021.
15/9/21?
Yes, ma'am.
What does it say?
Well, this is in respect of the appointment.
Qualification.
Yes, exactly. That qualification and subsequently age relaxation was there. So far the age relaxation is concerned, only age relaxation, except that all other things which has been incorporated in the original advertisement,
So
that
only,
remains intact.
Qualification remains intact.
Yes.
So as on the last date of the first notification, that qualification should have been acquired.
Yes.
So extension of the period for applying under the new
amended
notification would not amount to extending the period for acquiring the
qualification only and except the age relaxation is concerned. And
courts have viewed this point.
Lord, it has been in favor of the respondent employees. And in the meantime, another set of matters is pending before the coordinate bench of this Hon'Ble Court. And that is also is in progress.
That is in hearing stage.
Hearing stage.
The progress. We will complete the accomplishment itself.
Yes.
So that it becomes an order handy for them.
Yes.
No, what's the point? Your point. That's the only point.
That's the only one.
The qualification acquired subsequent to the cutoff date in the earlier notification. Is no qualification.
There is no qualification for the purpose, as it stipulated in the advertisement itself.
How the second notification?
Yes. The second notification is of 6/7.
You have delivered a judgment on the same point, but we cannot in a position to get it. First, we keep it to some other day so that we can collect.
We are completing it. No, some other day. Yeah.
My lord have answered this.
That particular thing.
That another coordinated.
Here only. Take out that judgment. Give that number. We'll take out that judgment.
Just somebody told me that is the difficulty. I have to search it.
No.
They say within 1 or 2 weeks is there.
No question.
Okay.
Yeah. Yes, brother. How we view this? See, why it was extended?
So far the age is concerned, because of the age.
Why the extension? Why the upper age limit was extended?
Milord, first advertisement was 27/10/2014, Milord. We
have passed we have passed one judgment on corrigendum and something in the advertisement. Where is our boy? Researcher. Call that boy.
10 days, 1 week before.
You only had.
That last year date that if at all it is in cut-off date, then it has to be considered because of the earlier occasion, it has to be merged with the.
That's how we have taken.
That's all.
And the judgment of a division bench.
Coordinate bench.
Coordinate bench. Incidentally, I was also the counsel. Data copy.
Same point and service.
I'm giving another.
Chief Justice Court.
Justice Mundal.
Give that.
Division.
That we followed in that corrigendum judgment.
Yes.
Perhaps you have written that.
This is a case of Tikas Act. Same thing. Same.
Advertisement, same process. For a 15.
Relying upon the judgment of that. Yes. Rekha Chaturvedi and Padma.
That was taken in Rekha Chaturvedi case.
Yes.
Which has been earlier.
Which paragraph?
Para 8 Millard have a glance to that.
16.
Yes, para 16 years.
15 and 6, the qualifications. My lord followed that.
Rekha Chakravarti also quoted in paragraph 8.
Paragraph 8, it has been quoted.
Quoted, yes.
Do you have that copy of our judgment?
That judgment I have.
Give that, find out that judgment. I think it was about
very short time.
Yes,
10 days before.
maybe the ink also
There
has
is some
not
trying
come.
to find out.
Before
10 days before.
Give that. Right now. What the tribunal, is it from tribunal or level?
No, it is from the single judge.
From this single bench.
Originally, it was filed before the tribunal. Because of the abolition, it was transferred here.
In all these, kindly be seated.
Yes, sir.
Kindly be seated. In all, Mr. Bansi, kindly be seated. In all these petitions, come on. The state and its functionaries calling question.
Only one point I can agitate.
Yes.
In addition.
Then,
So for a qualification under the particular advertisement under clause 3F, there are
remains intact. Qualification is not changed.
There are two categories. One is of trained, another is of untrained.
Trained and untrained.
Exactly. For the scope of untrained, they should be bachelor degree with Hindi as one of the optional/honor subject with a minimum of 50% of the marks aggregate and MA in Hindi.
Bachelor's degree in Hindi.
With Hindi.
Document has come, please. 1306 of 2025. State of Orissa versus Nirupama Jana, please. Nirupama, yes.
With the Hindi.
With Hindi,
and
one of the optional or honor subject with minimum 50% of the marks in aggregate and MA in Hindi.
One subject in Hindi.
Yes.
Plus MA in Hindi.
MA in Hindi. So far this
other category.
Untrained category is concerned, this is and they have been allowed to go on in-service training so far the PD is concerned. So far the trained graduate is concerned, that is at the first step. In both ways, they should be graduate.
Whether that is changed in the next notification? No.
No, Miller. They have acquired that qualification when earlier advertisement in 2014 was there, that is not been acquired by the candidates, for which they have not applied for this. When age relaxation come into picture by this Hon'Ble Court in 2016, they have applied.
Notification says those who have already applied need not apply.
Need not apply. But these candidates have not applied because of the reasons they don't have any qualification.
Others also can apply.
Others can apply because they have the qualification. Because these persons are much after the cut-off date.
Mr. Mahant, please sit.
Very point we have treated in our bench, brother and myself, we have decided that.
The Vishwaranjan
matter. Para 4, Mr. Komanthi, do you have copy of our order?
I have the copy.
You have copy?
Yes, ma'am. That is Swechasevi Shikha Sahayak, and this is Hindi teacher, contract teacher in here.
We had one something to and having perused the appeal papers, an indulgence matter.
But this corrigendum is not same. The one which is involved in this case.
No,
that is different.
It is not corrigendum. It is a fresh notification in your case.
This is
extending the
and that is by virtue of this honorable court's order.
Yes.
They have considered it and extended from 32 to 42.
Yes. But you written now. Calling in question. Whether common judgment or a series of common judgment?
No, my lord, it's a common judgment.
one judgment which has been followed in other cases in terms of the judgment.
15/9/21.
The common judgment dated 15/9/20. Kindly be seated. 15/9/2021. Entered by a learned single judge of this court. In WPC VAC 1102 of 2017, 3219 of 2017. You can say 1613 of 2017. First time. Come on, whereby relief has been accorded to the writ petitioner as under. Go to the relief column. So it should be. Para 30, 1-3. Next paragraph, small one. We are told at the bar that this judgment has been duplicated in rest of the matters. Yes. Yes. And the rest of the matters that happen to be bunch of cases for consideration at our hand. First come. Next paragraph. The subject matter of these appeals, appeals involve the jugular vein of all these appeals is as to the extension of the cutoff date for applying for the posts in question by those who had not applied under the earlier recruitment notification. First up. This happened eventually because of another coordinate judgment in WPC number, which is WA number.
102 by 2016 disposed upon
102 of 2016
disposed upon 29/11/2022
between
Vishwaranjan Vishwal versus State of Orissa and others. Vishwaranjan Vishwal and others versus State of Orissa and others.
They said extend the period.
They said that
No, on the basis of which these actions are.
This extension, Mr. Mohanty.
No.
That is different. This is.
That is a different case.
With
Sorry.
that judgment, Mr. Mohanty.
That is way in the trial.
That is OA, my lord.
In view of.
That is in OA number 3589.
Because of tribunals administrative, Orissa administrative tribunals order
17
OA number
17/12/2015. OA number is 3589 of 2014.
between.
What is, I'm saying.
Just look at it. So
And date is 17
on
17/12/2015.
17/12/2015,
Where upper age limit is extended to 32 to 43.
wherein a direction was given for extension of the upper age limit from
32 to
32 to 42 years of age. First off. The subject matter of this, you have to share the fees. The subject matter of all these appeals are the question raised in all these appeals need not detain us for long, the same being no longer singular. Wide. The judgment of a coordinate bench of this court in writ appeal number 102 of 2016 between Viswaranjana Biswal versus State of Odisha, disposed of by the coordinate bench on 29/11/2022. First off, we have the benefit of advantage of looking to our own judgment in writ appeal number 1306 of 2025 between State of Odisha and others versus Nirupama Jaina, decided on 5/2/2026, wherein paragraph 4 reads as a first off, in view of the above, these appeals being unworthy of merits are liable to be dismissed, and accordingly they are, courts in the circumstances having been made easy. First off, the order of the learned single judge, the impugned order of the learned single, orders of the learned single judge shall be given effect to within a period of
3 months.
3 months.
Other
In
matters
outer
are
limit of 3 months.
bunch of matters are there. Scrutiny.
Outer limit of 3 months. Okay. Without driving the respondents to the coercive action in terms of contempt, Contempt of Courts Act 1971 or the like. Okay.
All the writ appeals have been.
All the writ appeals. Yes. Just the structure the judgment have to put. Yes.
In this, there is 4 petitioner. So on my submission, my letter, if any other loan dues is there. So they have submitted 4 dues, asserted that this related to all these petitioners' dues. But in that, page 15, they have total contractual dues, housing loan accounts. That is the surface issue action where 1,44,67,000 minus 10,54,000. My lord also recorded that amount paid. Rest of the amount let him pay and बाकी जो है उसके लिए discussion करेंगे जो कुछ होगा.
Question is, my lord, the land was put to auction. Auction has been fixed. Whatever amount due to me, I am liable to pay. And while your lordship passed the order, your lordship has also stated that there may be other loan also. So whatever is relating to me, I am liable to pay that much. But they have given, my lord, all. The daughter who has taken the education loan, the CC loan.
Were you the surety?
No.
My lord, can the petitioners, my lord, can you see 4 petitioners?
What she surety?
No, my lord, 4 petitioners. So why he has come, all the 4 people, why is one should come? Why 4 people have come? If surety is property is 1, why 4 people?
Don't worry. That's a cost title is prepared in the lawyer's office. Okay, court fee, saving the miscellany, so many things are there. Question is, what for she was the complaint of Nani Jena was whether he or she had executed the suretyship or guarantorship is the question. Merely because they are in the cost title. Can you do like that?
No, my lord, they are co-borrower in some account.
Sure,
but here I ask them.
Wherever they are co-borrowers, they are bound to. Wherever they are not, you are bound to. Simple.
My lord, 1, 2,
which other, now the loans which...
I am liable to pay only 1, 2, 3. Your lordship may kindly turn to page 14 of my IA.
14 of IA?
Yes.
Now what they are saying?
They are saying they have...
The other 4th loan also you are liable to.
They have 14 loans. They have indicated 14.
How much? How many loans? You just ascertain and file us.
Ascertain कर दिया, लिख दिया है. उसमें, my lord, kindly see the page 15 of his IA, today's IA.
Correct.
My lord, page 15.
Civil Township Branch.
My lord. My lord, kindly see the total
7 to 14.
14. And total, in बाद में लिखा है, total contractual dues.
6 crore 98 lakh.
No,
6 lakh 98,000.
Last before para. Page 15.
That is
total contractual due.
10 lakh.
In housing loan accounts, rupees 1,44,67,993, out of which you have paid 10,50,000. So means another 1 crore.
Based upon which? How you have calculated that?
My lord, is the first 3 loans.
First 3 loans allowed?
No,
allowed.
My lord, your lordship may kindly see.
1 second.
Yes.
3 loans you are saying.
I am saying 3 loans.
You are saying 3 loans. 3 loans are they are there in the first para page 14.
Yes, 14, 1, 2, 3.
1, 2, 3.
Yes.
The rest of the loans are not concerned to you.
Because your lordship may kindly turn that page in complex.
Brother, you call your who is your is it LIC?
No.
Bank of
India. You call your Bank of India people who will be able to advise you.
What is challenging, first to say. My lord, possession notice.
Correct.
Possession notice, there it's a loan dues has been mentioned. That which year they have challenged. But because of this, my lord has other loan is there. So I added that other loan.
Other loans are not concerned with her.
My lord, they are co-borrowed, but
show that.
That code, my lord, just a minute.
It shows whether they are co or not. Co-obligant, guarantor, surety.
That we know that, but property related to housing loan attached.
That makes no sense.
Property.
You can proceed against your borrower, against your guarantor, against your surety. Can there be anybody within whom the bank can embrace? It cannot. Therefore, call your officer. You are more on law. She is more on banking. This court wants to strike a balance between these 2 extremes. We have to see the banking. We have to see the interest of the lender also.
Minor.
Yes.
So for that reason, they have, when they have sent the notice.
So, no, but yes, this 1, 2, 3, which you claim to be due, that in fact comes to 1 crore 44.
Yes, that is true. I am not there. My lord, your lordship may kindly see that page 14. In compliance with the aforesaid order, we hereby furnish the details of the total outstanding amount as instructed as on date. So the details amount I have to pay.
My lord, they have specified that you pay this amount.
No.
My lord.
How did Tamil Selvi Pillari is the, of course, that concerned. Murthy Sumit Pillai is concerned.
Because they have made party.
Your liability arises under the loan agreement.
They are also liable to pay. That loan account also liable to pay.
Correct. Why they are liable?
Here it is not added. My lord. For that reason, the specifically said, after getting is what my humbly pray.
No, not like that. Simple. It's a question of banking law. Contract law.
For this, they have specified. So you should have contacted why this thing.
No,
they have not
no, you are here. You tell us. You want to put your hand into the pocket.
Right.
You should say on what basis you are putting your hand into pocket. No, we are a pocket or purse. Whatever.
Kindly see the order, madam. Kindly see the for a minute, madam. Madam, this order on my say that may be considered as my fault, maybe, or my say. Any other loan minor has
Any other loan is not excise that goes in the market.
Yes.
It is off with which the petitioner is concerned.
Petitioner is there. Minor, all these loans,
Show that.
12, that I'm so.
Show that.
12 loan, 14 loan.
25 loan.
Either way, the petitioner is involved.
Show that.
That
merely because in cost title ABCD is mentioned. It's a lawyer's prerogative to find the cost title. Keeping in view
with due respect, my lord, that is confusing. When I have communicated the order, that is my fault.
No.
Then now it is specific. Let him pay that specific amount. That,
which amount?
That they have clearly mentioned. My lord, can you see page 15?
That 150.
That extent is
134.
1, 2, 3.
1,
1, 2, 3, correct.
144 minus 10 lakhs.
Yes.
Those who are paid.
Yes.
But you pay.
I am liable for that.
The pay.
This application is for what?
For modification of the order.
Modification of the order. This application supported by an affidavit is moved by petitioner number.
Petition number 1.
By petitioner number 1, contending that she is liable to pay only 1 crore 44. Your bank manager may be calling you. After seeing the discussion. 1 crore 44 lakh 60. 1 crore 44 lakh 67,993. 0.63, as has been mentioned in the bank document dated 11/2/2026, a copy whereof avails at Annexure 6 to the application. First one. Next paragraph. Learned counsel appearing for the said for the applicant submits that his client is liable to pay the loans of serial numbers 1, 2, 3 and 3, namely 1, 2 and 3 in the table, which is as under. See this, only 1, 2, 3, page number 14. Okay. 1, 2, 3 alone you mark that. Just impossible marking. And rest of the loans are not concerned with him. First of all. Learned panel counsel appearing for the bank submits that even that amount is quantified at rupees
1 crore.
How much?
No, that is not true.
So that 1, 2, 3 are agreeable.
Yes.
Learned panel counsel appearing for the bank submits that if the applicant pays off the money is due as shown in the 3 borrowers account numbers, that is, see there, account numbers are also there. 520, 3777, comma. There would be no difficulty for what they should do.
On deposit of that,
I will deposit it. Your Lordship may kindly grant me 10 days time.
You will deposit and then what happens?
They will close down, everything will be closed.
Account will be, loan account will be.
auction will not be held.
Auction will be held.
She will be discharged from liability also.
Particularly these three accounts.
Yes.
But rest of the thing, what about mine? He will discharge.
For granting discharge to the said applicant.
Yes.
With regard to these three accounts.
That's fine. First of all, with this proposal, counsel for the petitioner is petitioner bar applicant, applicant petitioner is agreeable. And she seeks a period of 10 days for making this payment, for making this remittance, with interest accruing due thereon up to date.
And minus the 10%.
It hardly needs to be stated that whatever amount is already remitted in that regard needs to be given discount. First time. With this, the panel counsel appearing for the bank fairly agrees. Since it's a matter of accountants. First, with the above observations.
Then auction fixed on 25th, maybe continue, may not be
No, my lord.
confirmed.
That
Can they say, oh, if you will not pay 10 days, not the 10 paisa he has not given.
Then within 10 days, if you do not pay, till they will not pay.
My lord, I am making a submission before
No.
your
The
lordship.
last occasion also made, not a single pie.
My lord, 10 lakhs I have already paid.
See, so prior to that.
Yes.
That was at 26th of December.
Yes, my lord, that is
So
true.
the order,
If you do not make this payment, what should happen?
My lord, then they will proceed.
Yes, sir. Again, another
In the
option.
event payment, whatever.
Well, option will be made, will not be confirmed. Confirmed.
And then there
Will not be confirmed. After 10 days, it will, we will close it.
The matter.
No, my lord, nothing is there. Unless we will issue certificate, nothing will be there.
Shall be given discount. This will be given due discount. First off, if remittance is made accordingly, the auction shall not be confirmed. Auction scheduled to be held on
25th.
25
February.
February 2026 shall not be confirmed. First. However, if the money is paid before auction being held, the question of holding auction will not arise.
Tomorrow.
Highly obliged.
Tomorrow, my lord,
What
auction has
should I?
been.
You are not.
But one more thing, my lord, because of this letter, I am unable to pay.
No.
That
You
one
should have-
more thing.
Whatever according to you was due, you should have calculated and put that money into the pocket of the remittance.
Yes, I will pay.
Above the
If
list.
not, then
Yes.
your lordship may kindly,
Nothing like that.
my lord, grant me this urgent copy of your lordship.
Yes, sir. Print it immediately.
Obliged.
This is pension matter, my lord, covered by Dharandhar Ratta, my lord, which has already been affirmed by the Honorable Supreme Court, my lord.
Just a month is.
My lord,
Here, my lord, give copy.
This is job contact employee.
Yes, sir, covered by judgment, na? Wherever matters are covered, do not trouble us. We understand your difficulty because what a performance you have done in the court, they will be looking. We all understand that. But still, you are not the mouthpiece of your clients.
With all humbleness, it is our duty to ventilate the certain things in order to save the time also.
Provided there is you cannot go on ventilating the things again, again and again.
Not that way, my lord.
Yeah. Which paragraph courts, brother, show it?
My lord,
OJC.
OJC, my lord.
What's your prayer?
Prayer, my lord, to grant to regularize service and grant the benefit of pension and he retired from service in the year 1919.
How many years of service you have put in?
I am already putting, my lord, 32 years.
33?
32 years, my lord.
From which date to which date?
Join in 1959.
long before both of you were born.
Exactly. Exactly. And
1959.
Exactly. And retired on 11/7/1992.
30, more than 32 years.
32 years somewhat. There no system for pension. But however, taking into consideration the order of this Hon'Ble Court, Miller,
yes,
they have been considered as a Odisha extraordinary pension rules, which was in 43.
Extraordinary pension rules you have.
That is not followed in That's followed. Rajlakshmi has followed them.
Well, granted pension under rule 18(6) of Orissa Pension Rule 92.
18(6).
18(6), blood. 18(6) of Orissa.
18(6) is the new amended rules. My lords has passed this judgment in Sudan Sujana as well as the S.C. Malik. Wherein 18(3) for the work charge and 18(6) for the job contract. My lords has rendered the judgment.
Correct.
But this person is retired since 92.
Correct. But this 18(6) rule came, this is a post-retirement rule.
Post-retirement, but this is in 92, Miller. Earlier it was the 43, then it was 77, then in 92.
Then same should be given benefit of that to him. It's a pension matter. Pension, you have seen D.S. Natara and there is one on that
Miller, that
Devaki Nandan Mishra.
Devaki Nandan Mishra.
Because of that, this have to be given with retrospective effect. It is already given to others.
My lord, I have already given the judgment copy, my lord, which has already been affirmed and the government order is there, my lord.
In Rajlakshmi case also. Rajkisar Pardhan.
In Dharanidhar.
That is in case of Dharanidhar.
Dharanidhar Ratha. He retired from service in 90.
Rajya Lakshmi case is something different.
Right.
Whether this was not challenged in it's a DB order, OJC.
Yes, my lord.
This is the OJC. OJC.
Their judgment.
Who is in
division bench?
Division bench, all right.
Division
bench.
But this is serial number? Look in the weekly.
There is a delay.
Of how many days?
300.
Delay, my lord. This is 315.
15. That's another ground for denial of justice. Right.
And approach in 2023.
True. But what he should do? A retired person. In case of retired person, see, another angle is there. Whatever terminal benefits are payable in a rule position, that you have to pay. Otherwise, it's not a question of recovery of money. It's not like a money suit. Whatever you are holding payable to an employee.
Legal entitlements.
That is his legal entitlement. And you hold it in trust. You are a model employer. You are not some businessman of industrialist to say that no, you came very late and therefore we'll close the doors. That is not the object of our constitution. You hold it in trust. It is payable to him. Against trust, no limitation runs. That's the beauty of law of trust by Snell's equity and trust. These aspects are Snell on equity and trust was one of the books which had impressed Mahatma Gandhi. He mentions it in his autobiography. My experiment, story of my experiments with truth. He has mentioned, I vividly remember. He liked that book like anything, and he liked Sir Firoz Shah Mehta. who had by hearted the entire all provisions of CPC of 1908. Therefore, question of delay, at the most what you can do is you will not be entitled to the interest on what is paid. That we can, we will say that way. All right. Interest you are not, yes, you are not entitled to because of this. It was state and its functionaries are knocking it, in this intra-court appeal for calling in question a learned single judge's order dated 7/2/2024, whereby respondent employees WPC number 2246 of 2024 having been favored, the relief has been accorded to him as under print para 586. Together. Next paragraph. The appeal has been filed with a long delay of 315 days and an appeal 285 days. And an application supported by application in I number 8748 of 2024 supported by an affidavit accompanies the appeal memo seeking continuation thereof. First one. Learned, next one, we make it mark up. The next. Learned AGA Mr. Mohanty in his usual style vehemently argues that the infused order is liable to be set at naught since it tends to give the benefit of a particular rule, that is Rule 18.6 of the Pension Rules 1992. Orissa Pension Rule 1992. In as much as when these rules were enacted, this amendment rule was enacted, the respondent employee
retired Machak
had emitted office on attaining the age of retirement. On 11/7/1992, his entry point being 1912-1959. First off, he also tells us that howsoever long a service might have been rendered, unless the same is taken cognizance of by the rule maker by a specific provision, no relief of the kind could have been granted by the learned single judge, and therefore the interference at our hand is eminently warranted. First off, kindly be seated. Learned counsel appearing for the respondent employee repels the above contentions, making submission in justification of the reasoning of the learned single judge on which the impugned order has been structured. First off, he tells us that the question of delay, latches, etc. would pale into insignificance, the appellants being the model employer in terms of apex court decision in Bhupendra Acharika versus State of 2013. Yes, it's right. So first of all, further he tells that the amount payable by way of pension is not a bounty in view of DS Nakara versus Union of India, and that the model employer holds the amount so payable as terminal benefits by way of trust. And therefore, the principles of delay and latches, as would govern a proceeding for recovery of money, would have to stay miles away. See, his contention will make a separate paragraph. Next one. Having heard that, lastly, he places at our hands a coordinate bench decision in OJC number 13471 of 2001 between what is this?
State of Orissa versus Dharanidhar
Rath. State of Orissa versus Dharanidhar Rath. Disposed of by a coordinate bench.
29-9.
Disposed of by a coordinate bench of this court by order dated
29-9.
9/9/2011, which learned single judge also has referred to at para 5 of the impugned order. First, next paragraph. Having heard learned counsel for the parties and having perused the appeal paper, we decline indulgence in the matter for more than one reason. Follow.
This is also confirmed by the apex court.
Okay. The learned firstly, the appeal has been filed after booking inordinate delay of 220 days.
315.
50.
It is in the
In our calculation, it is less than that one. Okay. First of all, although an application supported by affidavit is moved, seeking its condonation, we do not propose to condone in as much as it is only a routine parroting of the regions. First one. That apart, in matters like this, where a person has put in a long service of more than 32, long and spotless service of more than 32 years, he cannot be put to trouble in an appeal belatedly filed. First one. Even merits also are lacking in the main matter. First one. Keeping in view all that, we reject the application for condonation of appeal. First one. However, we want to undertake, we would like to undertake examination of the matter on merits. Next point. The respondent poor employee, as already mentioned, has put in an unblemished service of 32 plus years during 1912-1959 and 11/7/1992. First up, our constitution through the directive principles provides for humane treatment of employees and workers. First up, that apart, the appellant, kindly be seated. That apart, the appellants are the state and its functionary who have to conduct themselves as model employers. Wide Bhupendra Hazarika, Sutra. First one. Further, the state cannot create a subclass within the class of pensioners who do constitute one homogeneous community for all practical purposes. First one. Therefore, the contention that Rule 18(6) covers only those who gained entry to public service post their promulgation would not advance the case of appellants. First one. Next paragraph. The other reason is the decision of coordinate bench in we mentioned that one. First, learned single judge have structured the impugned judgment on the basis of this decision, and that cannot be altered in any way, in as much as the like cases have to be decided alike. First up, we are told at the bar that this decision has been affirmed by the apex court in SLP number 1246 number 467 of 2013, dismissed on
16/8/2013.
16/8/2013. First up. Thus, The view of the coordinate bench has secured imprimatur at the hands of the Apex Court of the country. First, even otherwise, justice of the case warrants no interference in a state appeal of the kind. In the above circumstances, the appeal being devoid of merits is liable to be rejected both on merits and limitation, merits and delay. And accordingly, it is, courts having been very reluctantly waived. First up, the appellants shall give effect to the impugned judgment of the learned single judge within a period of 8 weeks, failing which whatever amount is payable in terms of terminal benefits would carry interest at the rate of 1.5% per mensum, which component may be recovered from the erring officials of the department. Okay. All right.
Well, may I
to add one sentence somewhere is put. My pension is not a bounty. Reiterated the Apex Court in Nakar, DS Nakar.
Milord, may I pray, Milord? Similar matter, Milord, item number 88, Milord.
88 also same.
Also same, Milord.
88 separator. Mr. Monty, 88 is it same?
Same.
Then the same order.
Of course, it is allotted to.
Same.
We will check it.
Right. Separate order. State and its functionaries are in appeal, in intra-court appeal, calling in question the order of learned single judge entered in WPC number single judge. Whereby respondent employees WPC number so and so having been favored, the relief as under has been bestowed on him. Okay, that is next paragraph. The subject matter of this appeal is substantially similar to the one we treated this day in writ appeal number 3396 of 2024 between State of Odisha versus Rajakishore Parida. First up. That appeal came to be has been dismissed, fixing a period of 8 weeks for giving effect to the impugned order of the learned single judge. First up, same case needs to be treated similarly, being the grand norm of adjudication. First up, next one, in the above circumstances, this appeal also fails. First up, the impugned judgment of the learned single judge shall be given effect to within an outer limit of same conditions of Patna. Reprint it here. Very which signs the signs. Next.
Item 3.
Yes.
The state appeal. Apart from the merit, there is a delay of 231 days.
231 days.
Yes, ma'am.
What is the reason for delay?
Yes. Another matter is also pending. One lecturer who has joined in service.
Which is that matter? Another matter.
Another matter is WPC number 5769. 2022.
2022.
Yes.
We'll call this matter along with that.
Because that is in respect of the departmental proceeding. During pendency of the same, he has filed to release certain amount. This is the order of the single judge, which is
same litigant.
Same litigant.
Call this matter along with WPC number so and so.
5769.
After 2 weeks. After 2. Okay. At the request of learned teaching. Next.
Lordship, item 4.
Yes, Lord.
There's a delay of 5 days.
5 days?
Yes.
Who your opponent?
Lordship.
Collector?
No, I am for the appellant.
Who is your opponent?
opponent is also state parties along with the petitioner before the
Other private parties also there.
Only one.
only one.
Only
That
one,
is
six.
respondent number 6.
All right, what is the point in what? Tell us.
Lordship, actually, respondent number 6 was appointed as an Anganwadi worker in the district of Ganjam. Now, it was a temporary appointment. She was disengaged through a.
How long she worked?
I'm not aware of the exact duration, but after the disengagement, what happened is she challenged the disengagement letter through this petition, which is impugned herein.
That was rejected by the learned single judge.
No, that was allowed. Now what happened is, in the meanwhile, a fresh advertisement was issued. Through that advertisement, I was engaged for the same post. But owing to the pendency of the writ petition, my appointment was stayed, subject to the outcome of the writ petition.
That writ petition by respondent number 2.
Respondent number 6.
6.
Yes.
By up to 1 to 5 are official respondent.
Yes, ma'am.
Yes. In the meanwhile, I filed an intervenor application and that was allowed by the Honorable Single Judge. Now, in the final disposal order, the petition is allowed. Thereby, she being reinstated into that post and consequently I being disengaged. So hence I am challenging that order of the Honorable Single Judge.
You were appointed to her vacancy.
Yes.
Then what you have then?
Lordship,
if her disengagement is wrong.
Her disengagement is right. That is my stance.
How?
Lordship, because
why she was disengaged?
She was disengaged because of 2 reasons. One is because of the irregularity in her appointment, and second being because of some disciplinary
irregularity.
Yes, because it was not approved by the Mahila Sabha of that area, and moreover, Lordship.
Is 42 that impugned order.
But if in the impugned order, that was not mentioned.
No, only on the ground of medical.
That was not the ground. You have seen that. Yeah, that is that 1978 SC 851. Mohindra Singh Gill versus
Mohindra Singh,
Chief Election Commissioner. An order, validity of an order has to be adjudged on the basis of reasons contained in its womb. That's what Justice Krishna here said. By judgment decision.
Lordship, the very advertisement by which she was appointed, in that it was clearly mentioned that she might be, since it is a temporary appointment, she might be removed without stating any reasons to that regard.
But they have given reason, which was found to be wrong. Had they not given reason, what you said is right.
So, but her whole stance was, I was not given a chance to be heard.
What is to be said? Now we will give you a chance to. See, what is the reason for removal? X is the reason. Correct? X was examined by the learned single judge. And he said, no, this is not correct. So that order has been set aside. Eventually, reinstatement of respondent number
respondent number 6.
6. No, not 6. Respondent number 6. Or 6 happened. So, in the meanwhile, to that vacancy, eventual vacancy, you were appointed.
Not sure.
Then you have to yield place. That will be list pendants.
I agree, but
nothing.
Since issue is that I am also being aggrieved because my employment is also which was the source of.
There is only one apple which you can share with one lady. It cannot be cut into pieces like a child, baby. With Solomon said, cut and give one half to this lady mother and other half to the other mother. The true mother said no. The same is the case here. You were given the engagement to a position which was vacant because of the removal of R6.
Yes.
If removal is altered, you have to replace to R6. So simple. Nothing.
Basically,
any other vacancies available there?
No, my lord, it said 2019, my lord, because the appointment is of 2019.
Correct. Suppose if there is any other vacancy, then the period of service she has put in, give that relaxation of the age. We have to individualize the justice. Court 226, 227 court has to individualize the justice. It cannot simply say, no, go, nothing like that. But otherwise, injustice will be caused to this candidate. If there are other vacancies, accommodate her there. Because you are happy with her working.
Now unless you will take instruction.
You take instruction. For this matter, but to next the request of the AGA, who wants to confer with his claims as to availability of some other position for the appellant hearing, who has put in how many years of service?
She was joining initially 2019.
Who has put in more than
2/3/2019
service. 2/3.
Yes.
Then more than 6 years she has put.
And this is the judgment of 2024.
So then
Near about 4 years some odd.
No, she was removed. 2024 is a judgment, all right. But removal happened in 2019.
Decision 2/3/2000.
Yes. 2019 only.
19 to 24.
2/3/2019 joined.
2019 joined.
This lady joined on
2019.
2/3/2000.
That's what I'm saying. Therefore, it must be more than 6 years. About 6 years.
ये पिला के भी जान करो client के भी जान कर
No, anyway, one thing for certain whether any post or position is available. Because she has that.
Even notice may be issued to the respondent number 6 at least to the
case is made out. Okay,
I will take instance.
After 2 weeks.
Lordship.
Yes, next.
Lordship, my appearance may be entered on behalf of ESMA purpose.
No, I only has heard 3. Fine. So
SK out on behalf of.
On behalf of appearing for the petitioner. Appellant. First up. Matter was heard for some time. And we wanted to ascertain availability of other vacancies in which appellant can be legally accommodated, or some concession can be shown in respect of age prescription for appointment thereto. First up, in this connection, Mr. Mohanty wants to confer with his official clients and come back. First up, call after 2 weeks. Next.
May I please, Lordship? There is a delay of 14 days.
14 days?
My lord.
What is the merit?
Merit is, my lord, National Industrial Tribunal Award. We just
award under IDEA.
Yes.
Under section what?
Under section, because it is referred by the Honorable Supreme Court to deal with this regularization matter and their benefit of service of the bank temporary employees. Safewala messenger like this. Industrial Tribunal has given a date, 1/1/87 will be the effective date. After the Industrial Tribunal hour, by 1/1/87, the Supreme Court judgment was dated 1/1/87. 198, sorry, 19, I'm sorry. Then Equation Committee was set up by central government to see who is fixed to what post. That was dated 22/9/91. So when the matter was pending, this amalgamation of different banks took place. It started from 2007. The original bank is Purigam Bank. Then Purigam Bank was merged with Gam Bank and became National Gam Bank.
That makes no difference.
No, why I am submitting that finally in 2013,
it became
a merger is there. We take the liability. That is not the dispute. Question is that a set of employees in as far as back, my lord.
In case of regularization, it is. Yes.
Regularization, they have already regularized. No controversy. They have got all benefits. Which will be the date? That date.
Effective date of regularization.
That date has been, it was decided in 90, a case was filed as far as back 94. And the case was finally adjudicated and finalized in 2007, confirmed by the Supreme Court. There, after looking that, those banks were not amalgamated with the present bank. They were there with the respective banks. They got the benefit. After coming over here, 13 years, 14 years, they filed a case showing that decision. We say that your service has been regularized, you got all the benefits, but rate of effect.
When they entered.
No, there's an amendment also. There's an amendment where Odisha Gramin Bank has become Odisha Gramin Bank. I have filed a kindly see.
That's all right. We do that. That makes no difference at all.
That I am submitting because that is an.
That makes no absolutely.
In that view of the matter, I draw my lord's attention to see the first judgment, which is that of this honorable division bench.
What is? Let us see the award first. How the
award has been quoted by the division bench.
No, the award which you are now challenged.
No, I am not challenged in that.
This is the order of the honorable single.
No.
Award is not.
Kindly see page 63.
No, you are appealing against the order of the learned single.
Single judge. Single judge says
appeal is maintainable.
Parity. Give the parity.
How appeal is maintained? It is 227. Award of the industrial tribunal is in the admitted jurisdiction.
Yes.
Do you agree?
Thereafter, yes, yes.
We are asking.
Yes.
Do you admit, which you are going to, it is an award made by the industrial tribunal in the admitted statutory jurisdiction?
Yes.
Right. Then if you have put it in challenge in 227, whether you use it 226 or not, 227, there is no intra-court appeal. This is what full bench of this court has said.
Labakumar
I am not on that point.
We are on that point.
Industrial tribunal award has been put to read jurisdiction.
We are on that point.
Read jurisdiction, my lord. Already a division bench has dealt that matter. National Tribunal award matter.
Yeah.
And fixed a date.
Yeah.
First date, the honorable.
The question is how appeal is, intra-court appeal is maintainable.
We say that
is not ready to listen to us.
Intra-court appeal because error apparent in the face of record.
That is no ground here. It can be a ground in 136.
What I say, our only two grounds.
Again, you first convince us that your
threshold is there. Threshold bar.
Rate appeal is maintainable.
Because of full bench decision.
Let me go through the decision.
No,
let me go
we are not here for giving tuition.
Because I have referred Arun Kumar case and two cases delayed. But can you see the enormous burden?
This already explained. So, first off, before the learned single judge, what was called in was the industrial tribunal's award dated sites.
No, that is not the case.
That's not taken.
No.
Industrial award is not put in challenge.
No.
But before the learned single judge, what you had challenged?
They extended the benefit of an earlier judgment of this court.
That is the award.
Whatever. Page 90.
Kindly see.
What you had challenged? What you had put in challenge before the single judge? Award of the industrial tribunal.
Industrial tribunal all over India. I don't mean that. My industrial tribunal has been put to scrutiny by a section of employees, by way of an association. The date of effect must be the date of the award.
Therefore, what was put in challenge before the learned single judge was the award of the tribunal.
No.
They wanted to borrow a particular date.
They want
in an award
with the earlier judgment of an earlier date. We say that cannot be a parity. That is the point. Kindly see the order of the honorable single judge.
Page 90, Judge.
Yes.
90.
90.
It starts from
80, but 90 is the.
That award, Industrial Tribunals Award said, the counting date should be the date of entry.
Date of
Entry into service.
No. It's 1187.
No.
That is there. The Honorable the Division Bench said no. It is from the date of actual engagement.
It went to Supreme Apex Court. Apex Court
confirmed it. We are not.
Division said what? Division bench said what?
Well,
Division bench said what?
Well, kindly see. Division bench said since it has been extended to the similar set of employees, why don't you grant it? We say that merger has taken place for different dates. They should have got it from the earlier bank. They have got all the benefits. Why they at a later stage, after almost 23 years, after merger, the Odisha Government Bank will take the liability. Notional fixation will be there. They have got the exoneration. So everything will be discussed. My lord, one more date may be given. I will put the entire facts in a very nutshell and point.
No date will be given in our court.
Okay, my lord. Then kindly see.
No date will be given that way. Merely
Kindly see our argument before the page 90, page 92, para 6. Because it's from merger start from different departments of banks from 2006 onwards. First writ petition is of 90. And these writ petitioners have filed first round for direction, consideration, then they file in 2020.
No, initially we have filed.
No, that I am saying. Consideration of a representative. We have only given two arguments as belated, a delay, and also the fence sitter. Nice. Chairman EP Jal Nigam, we have cited, the Honorable Single Judge also took note of that. The state of Uttar Pradesh, Varun Kumar Srivastava, as fence sitter.
Come to para 9 of the impugned judgment. It makes sense.
Mr. Senapati contends that since the respective regional rural banks were operating prior to amalgamation of Odisha Gram Bank, respective banks of such rural banks are liable to pay the entitlements to the respective employees, which cannot be now scheduled to the employers Odisha Gram Bank. Such submission advance on Senapati is not found acceptable for the simple reason that the entitlements to employees of regional rural banks and payment thereof on the date of amalgamation was never stated to be executed, excluded in the condition of amalgamation.
Correct.
When the entire liability of all such regional rural banks are being taken over on amalgamation to form the Odisha Gram Bank, at present stage, the employer Odisha Gram Bank cannot deny their liability in respect of those employees brought to Odisha Gram after amalgamation.
Correct.
And this decision was taken in 94 writ application, and they, after merger, they have got the benefit in the respective bank. After coming over, they say that give us the benefit from the date of regularization. We say you got it from the date of award, 1187. They say we must get it from the.
For others, we have done. The 1187, how many years of service already they had?
Different dates. They don't uniform date. The award says
minimum is how much and maximum is how much.
One date is 1187, 1987. Another 22.
How much time they had put by then in service?
It must be some around 5 to 7 years. 5 to 7 years, 6 years, like that.
You have given reason. See, also appeal is no appeal on the ground that another view is possible.
That I know. But what I say, kindly one aspect, it's a financial institutional ruin.
kindly see.
No ruining.
Kindly see, amalgamation took place, and why they slept over the matter of sitter?
All right, that they have put in.
They were there in the respective bank and got the benefits. Got all the benefits. Not that they are not regularized, not that they have got not the. Now, question is only from the date of actual appointment till the award
or from the date of amalgamation. That is the question. In the amalgamation instrument, you took over all the rights and liabilities of the amalgamated entity.
Oh, yes, admitted. Admitted. I don't deny that. But question is that why should take the liability what the earlier bank has already discharged?
Whether that, how do you say it was?
Because the only point is from the date of action, which is not known in respect to all the employees, date of engagement different.
No, you are saying.
The award says wherever the dates will not be available, because casual labor is not available, then the date of the what is called the 22/9/91 equation committee, where the central government set up 22/9/91.
22/9/91.
Wherever that there will be no date.
Where no date is ascertainable.
As to the date of entry.
Date of entry.
Where date of entry is not forthcoming from the record.
Yes.
Then 22/9/91.
Well, here
dates are forthcoming. Those dates.
Yes.
Those dates only.
Those dates.
We are asking you, sir, one simple question. There is Mukherjee on amalgamation. There is law of amalgamation by Mukherjee. He says, where amalgamation takes place, the entity that would come out of the amalgamation inherits all rights and obligations of those entities.
Admitted. I don't accept.
But if that is so, unless your instrument of amalgamation restricted the liability, you cannot take up a contention. We are not bound by it.
Question is that here, my lord, the award itself from the beginning says should be from first day of 87 day from Supreme Court judgment. Then that is page 64.
No, that
was modified by the Honorable Division Bench to the date of actual engagement.
Entry.
We don't deny all the judgment confirmed by Supreme Court. These banks, batch by batch, they were amalgamated. And before amalgamation, the earlier banks have extended the benefit of regulation. The only question is that from the date of it. That's not. And I have taken two decisions, my lord.
Yeah.
One is kindly see, fence-sitter. Because they have waited.
They're not, we don't call them as fence. It all depends upon whether you call the dog as the mad or not. If you want to finish it off, you will call it as mad dog.
No, we have relied on a decision of the Honorable Supreme Court. The state of Uttar Pradesh, Arvind Kumar Srivastava, and UP Jalal, but two decisions. It involves more than 304 employees.
Fence-sitter argument to be treated. What other?
That is UP Jal Nigam that already advanced. Honorable Singhal just said, this is not a retirement.
The
service matter, but ratio is ratio.
And therefore, there is nothing which the opponents of bank would undertake. Dismiss. Give that judgment. I would tell a name to be within what do you want any other period for implementation of the order, or we should make it?
See, give some more time to the bank.
Tell which, how much time?
6 months actually, because.
All right, we'll give them 6 months.
What I say, their records.
Impute order of the learned single which shall be given effect to within an outer limit of 6 months, which period is fixed on the basis of submission made by senior panel counsel appearing for the bank.
On the ground of records are not available. We will go to the earlier.
We are agreeable even otherwise also. We are agreeable. We'll give you 6 months.
I have only given one decision, two decisions.
One decision is sufficient. My brother is more efficient in the labor law than what I am, because I did not practice on the labor side, but I know also. Yes. Yes. Thank you. Next.
Item 6.
And the delay of 14 days of condone. Yes.
Item 6, my lord, I will bring for next week.
Next day.
Next week.
It's an opportunity for you to argue. Why can't you argue?
Matter not entrusted to me, my lord. I only
Your senior has not, does not agree that if you argue the matter, you would blame us. The judges are unkind and they did not give time at all.
my lord.
Start. If there is difficulty, we'll give you time. What is this, man? Is it RSA?
No, my lord.
It's a writ appeal.
This is writ appeal.
Under which section?
Section 10 of letter patent and
patent. What you are challenging?
My lord, challenging the order of Honorable Single Judge in WPC number 27566 of 2021. Which is
21.
My lord.
What is that?
The writ number 27566 of 2021, the passed in 27/11/2024.
Correct. You are right. Then what are the defects in the order of the learned single judge?
My lord, in this case, the present petitioner before your lordship, working as a storekeeper in working as storekeeper in the regional store Lakhanpur, under OP number 4, my lord. While he is working there is a department.
Learned single judge has denied back wages.
Back wages and other service benefits, ma'am. Because the present petitioner being convicted in a criminal case for the offence 13(1)(c) and 13(2) of PCF to read with 409 of IPC, convicted and thereafter by order dated CRLA 519 of 2008 is acquitted.
Issue heard learned counsel
Miss Agnishikha.
Yes, so and so who argued very well and made out a case for issuance of notice, issue emergent notice. Any delay?
My lord, 4 days delay.
But we cannot condone unless we hear. Yes.
Item 7. Much nice.
Yes.
Just the read challenge, my lord. Punishment in proceeding. My sole ground before the Honorable Single Judge, the very departmental proceeding was initiated by an incompetent authority. And my appointing authority, I have given the rule, quoted the rule, my lord, in paragraph 2 of the writ appeal.
Whether appeal is maintainable?
Yes, my lord.
Appeal department, no. There is the dispute as per 67B of Cooperative Societies Act.
67B, it is report score. But I approached the Honorable High Court because the proceeding was initiated by an incompetent authority.
That also is available to you.
Incompetent authority and alternate remedy, my lord. That remedy, my lord, before the tribunal. Therefore, because the court, incompetent authority and natural violation as well as justice. Therefore, it is mental. That was my. That part has not been considered by the Honorable.
But this is Cooperative Central Cooperative Bank is a state entity under Article 12.
It's a cooperative society. Cooperative society and
cooperative society, unless it partakes the character of an entity under Article 12.
Yes, madam.
It will. We cannot maintain the writ petition. There is the famous judgment of Justice B.P. Jeevan Reddy. 1983, 84, something like that, na? Go to 1980, Article 2. Which is that judgment? No writ against cooperative society.
The writ was
maintainable.
There is judgment of this Honorable Court also.
It is held that way, Article 1283.
Since it is discharging public function, my lord.
What public functions? Cooperative society?
Yes, ma'am.
Take out that B.P. Jeevan Reddy's judgment.
There is judgment of this Honorable Court also, my lord.
Which says this bank is a state entity.
Yes, ma'am.
Sure that. Is not there is no writ against cooperative society. It was from Andhra Pradesh High Court. Andhra Pradesh state of Andhra Pradesh. That is Andhra Pradesh Cooperative Societies Act. That's what.
The judgment of this Honorable Court.
You that?
I have not.
But what kind of advocacy? Yes. Arguing and time, taking time, killing time.
No.
On a call after 3 weeks, at the request of learned so and so.
Next treatment.
Yes, next.
Next treatment.
No. Next.
Item 8.
Judges have.
Delay is 23 days, my lord.
23 days.
23 days. Petitioner belongs to Nabarangpur, which is 600 kilometers away from Qatar. He is also financially very weak and is unemployed person. That's why he could not approach this unemployed in the right time.
What is on merits shares?
Millard.
On merits anything?
Millard.
On merits. On merits of the matter.
On merits.
Do you have anything to say?
Millard. Millard, the petitioner appeared. The civil constable is examination in the 2018. He got selected physically. Thereafter, he appeared before the for a written examination. In a written examination, he filled up the OMR sheet. OMR sheet, that is, he has written correctly the roll number in a numerical number, but while encircling the box, he has wrongly in the place of 1, he has filled up in 0. In the place of 0, he has encircled, which is for which the computer could not.
What to do? It's a mudra rakshasa. Your mistake.
No, this is
computer works on a 0-1 principle. What it can do?
Well, this is the mistake, but he has written numerically. He has written correctly. Lots of kind. Have a glance to page 12. Page 12.
What the apex court said in where computer does the mistake. It does not do the mistake. It does as per the things which were there on the record. So what the apex court judgment is taken on that? What it said. We have that judgment.
The Honorable Single Judge has taken this matter, has decided that the mistake committed is not trivial. This is serious mistake. But the Honorable Apex Court in similar cases that in Vasisht Narayan Kumar versus State of Bihar and others, that
what it has said. Of which year? Which year?
This is 2024.
In this case, Millard, what has happened? He has written wrong date of birth, for which in the final stage he could not be selected. So at conclusion, your Lordship.
Supreme Court
it was not mistake. It was not computer. It was not.
In this case, he has written wrong date of birth. The Honorable Apex Court hold it that this is a trivial mistake, but not grievous. But in this case, Miller, this is a purely technical. And also in this case, Miller, the invigilators, they have certain duty. They have to cross-verify the answer papers. And they have to, this is the duty that has been, they have admitted. In the, your Lordship, can you have a glance to page 22?
To take notice, let us issue emergent notice. Heard Local Counsel appealing for the appellant. First one, the presses into service of exploitation in 2024 INAC 2. Vasisht Narayan Kumar versus State of Bihar and other. To the effect that mistake of the kind committed by the client is trivial, and therefore that ought to have been rectified, ascertained and rectified by the selecting body. By the OPs, respondents, by the respondents. First one. Matter request for examination. Issue emergent notice. Learned AG requested to accept notice for the respondent. Okay. Let's go. Next.
Item 9.
9 is your Lordship, State Appeal, your Lordship, the delay of 323 days, your Lordship.
On merits.
Your Lordship, this relates to the appointment of engagement of non-formal education facilitators, Your Lordship. And the judgment that the single bench has relied upon, that is also under challenge, Your Lordship, in writ appeal number. Yes, Your Lordship.
Appeal number?
Number 509 of 2025, Your Lordship.
509 of 25.
Yes, Your Lordship.
Before us only. Must be before us.
Yes, yes.
You call this matter along with that?
Yes, yes, ma'am.
Call this matter along with the issue emergency notice. Learned you have entered caveat.
No, my lord.
You want to take notice?
I have already filed them.
For color.
Yes, ma'am.
Your name is shown here.
Yes, my lord.
Issue emergent notice. First one. Srimati Swayam so appears past. OP numbers, respondent numbers.
Only respondent. One.
Respondent. Contesting respondent. Sole respondent. Learned counsel, learned AGA, Srimati Swayam so submits that the impugned order of the learned single judge is structured on on another order which has put in challenge in writ appeal number 509 of 2025. And first time. He submitted at the bar that both the appeals may be taken up together in the fitness of things. First off, we agree. Yeah. Registry to post both the cases together.
Your Lordship, we may serve a copy on the.
Yes, you
So the notice.
It will come.
So the notice can be waived, Your Lordship. We will serve a copy within 2 days, Your Lordship.
Yes. Formal notice is waived. Appearance will there on behalf of the respondent. Yes.
Item 10. Milords, kindly pass over for the day because Mr. Swai on his leg in court number 1.
On his leg or on his feet? Which is the correct expression?
On his leg, my lord.
On his leg?
On his feet. On his feet. Sorry, my lord.
Which grammar book you read? You read?
Sometimes, my lord.
Sometimes you take this, you apply to the taking food, breakfast, bath, or regularly you do it.
Regularly.
Then you read regularly.
Because of chamber works.
Chamber work. With half an hour, 10, every day 1 page. If you read high school grammar and usage by Leonard Martin, it will increase your efficiency level. Linguistic quality standard will go up.
Sure, man.
Sure. 1 page every day at the bedtime. You make it a point. Without reading 1 page, I will not hit my bed. Sure. Even on bed also you can read.
Sure.
You do that. All right?
Definitely.
Next time you will show that book to us.
Yes, my lord.
Which book? Then.
Martin.
Mr. You tell him.
Martin.
Also just now. You show it next time when you come before us. But you have to bring that book.
He's like Lord Hanuman. Gandhamardan includes Visallakarani. So therefore he said leg. Leg includes feet.
You have made our day of human. Yes. All right. 2 weeks at the request of. Next.
Item 11.
Yes.
The present case is that the appellant.
Is it in Hanuman Chalisa?
Oh, no, Ramayana.
Ramayana.
There is a
Valmiki Ramayana.
There is a delay of 27 days.
What is
there is a delay of 27 days. Yes, that
merits what?
Yes, the appellant was a headmaster in charge of the aided school, block grant school. Since there is a dispute between the two persons, appellant and one Josna Mahanta, regarding the seniority, fixation seniority. By virtue of the order of this one code, I allowed to continue as a headmaster in charge. 2024, the original date was disposed of. At the WPC 3055-2011, dismissed by this one code, which I challenged. By that time, Josna Mahanta retired from service. So, During pendency of the road, one third man was appointed as a headmaster of school, another headmaster of this another school, but kept in charge of our school because of the dispute between two persons. I challenged that order in 2018 order. That order was quashed by this by Honorable Single Judge. Thereafter, the opposite, the respondent 3, with the competent authority, he directed to me to submit the proposal of the recon managing committee. That order was challenged by some teachers of the school, not the person that remains a hidden challenge. Some teachers who have no connection with the managing committee and some peons. They approached my lord, the Honorable Single Judge. Honorable Single Judge decided that in view of the modified order, you are not the headmaster in charge. That is under challenge.
There is a set of conflicting judgments of apex court on this point. For that we will issue notice. Let us observe. Issue heard from so and so appearing for the appellant first time. Issue emergent notice. Learned DGA Mr. Panda is requested to accept notice for 1, 2, 3 first time. First line that one. Then issue emergent notice to the rest. Yes. Next.
Item 12. Item 12 on behalf of Mr. Kashyap Manners, I am praying for adjournment.
3 weeks. Get the request of obligation.
Item 13.
May I please also?
Yes.
Well, this is a disciplinary proceeding matter. This is the second round, my lord. In the first round, it was remitted back to the disciplinary authority, my lord, to reconsider the quantum of punishment.
You are in the serial number?
13, my lord.
1-3. Chief General Manager versus so and so.
Yes.
You are for the bank?
Yeah, I am for the bank.
What is the point involved?
Point involved, my lord, the Honorable Single Judge, without remitting the matter, my lord, passed the order of punishment himself, my lord. Kindly come to page 45, my lord. On mistake of facts, my lord, kindly come to page 45. Apart from going to the law, my lord, you should look at page 45, 2 paragraphs. On due consideration of the defense relating to all allegations, which are 5 in number, the inquiry officer had recommended for punishment of reduction to lower scale of 5 stages for a period of 5 years, with no increment during the period of rigors, but not postponing increment on expiry of the period of rigor and not adversely affecting his pension. In the background of the allegation as has been made, taking into account the inquiry report, on evaluation of petitioner defense and the judgments, cited the bar to the proportionality of punishment, this court is persuaded to hold the reduction to a lower stage in time scale.
Take notice. Issue emergent. In fact, we have very notice. Learned counsel. Who is advocate on record?
Vajanti.
Srimati so and so appears for OP number.
Sole.
Okay. Next.
Item 14.
Not even fix up a date for hearing.
14 after appeal by the state. 14 is appeal by the state involving a delay of 78 days.
What's the point involved?
Point involved in my law and friend is appearing for the capital.
By a doctor.
Already appeared for the respondent capital. And if he has a copy of the writ appeal, then we can proceed for the
Yes, I have
copy. Achhi.
writ appeal.
Writ appeal.
Writ appeal copy. No. It's already
You a writ appeal copy. You should
collect. I have collected one.
The counsel Mr. Dodson, yes, for respondent, sole respondent. First time. There is a short delay of
78 days.
78. Less than 48 days.
48 days.
I'm sorry. 78 days.
78 lakh.
First time. An application is put by accompanying the first round. The delay is plausibly explained. First time. Therefore, the application having been favored, delay is continued. What is up to 4 weeks?
Madam, can it be next week? Next week, retirement benefit.
When he retires?
Like he got the voluntary retirement under Rule 42.
When he retired?
By order of the Honorable Court, my lord, it is 2024. But they are not giving the benefit. Because there is a, after not getting any.
Next week you want?
If my lord pleases. Oblige.
Yes.
Item 15.
15. What is this matter about?
15 also
281 days.
appeal by the state.
Now what's the point?
Involving delay of 281 days.
What's the point involved?
My lord, the judgment of the
Let para 5. You have already given appointment to rest of the people.
So
kindly come to para 5.
Those are pursuant to the order of the tribunal.
Correct.
And we are saying that they are not similarly circumstanced.
On what basis? Show them. Where had you taken up that contention before the learned single judge?
I am in our ground number.
And those who have scored less marks than people, you have given a point.
No, our contention is, my lord, lordship, basic ground number H at page 11. Ground number.
No, did you take up that contention before the learned single judge? A host of contention.
I will
did you take up that contention before the learned single judge?
May I
show this.
May I be pardoned to...
Or whether the learned single judge had not given an opportunity for taking up such a contention. Either of these two. Therefore, a contention not urged before the learned single judge ordinarily will not entertain.
Yes. Well, learned single judge has not taken the counter affidavit into consideration, but
read the counter affidavit. Which contention you have taken up?
That is the para 4. Mr. Panigrail on an ASC for the state submits that the requirement is of the year 2013 and hence reply is required to be filed.
Did you file
Admittedly,
any reply was filed? Where learned single judge told to file the reply?
No. Yes, but that is the final order. That is the final order.
May I pray, my lord?
How much
I am in the virtual, but I am in difficulty today. I could not appear. I may be pardoned. I am for the, my lord, the read petitioner respondent. I have the caveat. Only I pray let it be taken up tomorrow, my lord. In their impugned order, rejection order, they have admitted something that I will show on tomorrow, my lord. Let it come on tomorrow, my lord.
Not tomorrow. Perhaps we have to supply the rate appeal papers to him.
You furnish issue. We'll issue notice. We'll call it next week.
Let it come on tomorrow. I will be available, my lord. Today, my lord, difficulty of my father's illness. That is why I pray, my lord. Let it come tomorrow, my lord.
Call next week.
Yeah. Item 16.
16 may please lordship. Here lordship is a writ appeal prepared by the petitioner against the order at annexure 1 lordship. Here is a case lordship, may I repeat lordship memory, is a case where the petitioner, being a constable, he has been implicated in a criminal case for certain allegations. Then he faced the entire trial and he has been acquitted. The reason of the acquittal by the London Trial Court is that the prosecution miserably failed to establish the allegations. On this self-set of allegation, a departmental proceeding was initiated where the self-same witness were examined. None have supported the case of the prosecution, but the concerned SP has found it proper to punish this person with a 1 black mark and to treat the period of suspension as such. Challenging that, the appeal prepared. There also it was found it was upheld. And challenging that order, I had approached the Honorable Court and the Honorable Single Judge while dealing with the matter felt it proper to maintain that black mark, but the other part has been denied. That is what
black mark means what?
1 black mark was awarded so far as the petition is concerned, lordship.
No, what is meant by black mark? Right?
Black mark.
No, you know black mark. No. What is that black mark?
Lordship, may place page 1, running page 132. 132, running page. That is the annexure 8 was that.
In warning, there is censure.
It's, that says in that way, after
Contract law, I think we cannot do. In the PMR.
it is, because it is a police constable, so that reason.
One black
One
it's what?
It will affect his promotion. that's all.
Yes, it is a PMR. This is
Police,
My lords, PMR.
Police service.
Yes.
He is a constable.
Rule 824.
Yes, read.
Description of departmental punishments. The following punishments may be inflicted departmentally on a police officer below the rank of deputy superintendent. Here, my lords, dismissal, and here in F, black mark or marks.
Black mark?
Or marks. Marks.
Blacklisting, we know.
Blacklisting is
a punishment. It's a punishment. Maximum 9 black marks can be awarded to a.
What is the effect of black mark?
Well, after
Promotion will be
9
disturbed.
black mark, he will be terminated, dismissed from the service.
That's the accumulative point. That is. So one is given now.
One black is given, and the period of suspension are treated as such.
That is set aside.
That is set aside by the honorable.
You are aggrieved by the one black mark.
Black mark because it affects adversely to my promotion. Because I
Promotion also.
Yes, because
Where is that?
no, because when one black
is compared to this service, your colleagues.
pardon, let's see.
Equal in all respects, if they are equally placed, then he loses.
In all respect, if it is placed, then this man will not be allowed.
Also,
in fact,
one can argue that why I should have black mark.
black mark, and there is no matter. And Lordship, last occasion while I pressing the matter, your Lordship, please. Yes. That is right. Yes, I have gone to Ramlal. So also by your Lordship's husband, while sitting the Honorable High Court of Karnataka, yes, that has examined. The last occasion, last year, please to ask me whether I have been acquitted honorably.
Yes.
Undoubtedly, my case is that there is no such word used, honorable acquittal.
No,
but in the Ramlal case, Lordship, while dealing with the Ramlal case, your Lordship, please to decide that score, that although this honorable acquittal word is not available in any law, but it is to be inferred from the entire scenario. That is what the Lordship judgment I was dealing with. That I was going through that only. And in that
five parameters,
yes,
we decided in the Rudra state of Karnataka. If your case fits into any one of the 5,
yes,
then you have a case, otherwise not.
Not.
Which are those 5?
That's right. May I read the Lordship judgment only?
Only that 5 parameters.
That I have marked it. May I please, Lordship? I am passing the copy.
So read it. Both we have seen. Karnataka. I am the author of it.
देखो रुद्रा बना आप आउट I pass.
In fact, they decided we just
Here, para base 12 is the event in the Lordship is please take.
The false place to see such a finding should be there in the judgment.
Judgment, yes.
That there is absolutely no evidence to implicate the accused in the proceeding. There is very little evidence which is insufficient to connect the accused with the commission of
that is what my case. Roman 4 is my case.
Where is that?
Yes, I'm showing Lordship running page 86, Lordship. 86. Lordship. 86, para 13, Lordship. That is the observation of the learned trial.
Scrutiny of evidence of the laws, none of the prosecuting cases, including the informant and victim have support in the prosecution. Thus, this note comes to the case in the prosecution miserably failed to prove.
Miserably failed.
Beyond all the and the benefit of which they were.
This is what the case, Lordship. So
take notice.
I have there is delay of 3 days, Lordship.
Issue notice. Who? AGM?
My lord.
AGM.
Another
request accepts notice for the OP numbers
1, 2, 3.
1, 2, 3. Emergent notice to 4. Why 4 you have made a party?
Because that was made in the before the read court Lordship. So I am bound to make it. In the read court also she was not noticed.
Emergent notice to respondent 4. Okay.
Section 4 was also not noticed in that case. That's
First one. Once your case is decided against you, that will be in her favor.
no,
Therefore, she has right to.
and that's true. She was the enquiring officer only, so it's not.
Okay.
That's it. The delay was the
Delay, we have to serve notice on what people, no? Yes.
Item 17.
But after service.
Delay of 3 days in preparing this appeal.
What is on merits?
Because merit here this case, the petitioner was working as a weaver in a spinning mill. Because government floated a voluntary retirement scheme, and they opted for the same in the year 2000. Because in 2001, they were relieved from their service on the following the voluntary retirement. Because and at the time of their retirement, they were paid some statutory dues as per that scheme, but they were not paid some area salary, unpaid salary, and incremental dues, for which in 2002 there was an audit by the organization, and in the audit it was specifically mentioned that they are entitled to these things. In the meantime, lot of cases were filed before this honorable court. Honorable court directed for payment. The state government went up to the Honorable Supreme Court, and Honorable Supreme Court disposed of all the SLPs filed by the state, because there were 4 spinning mills, not 5 spinning mills. All had gone to the Honorable Supreme Court. That they said that the rupees 8 crores, 80 crores, and some was earmarked for payment. Honorable Supreme Court said that you pay that dues, and balance you pay in installments according to their eligibility. Thereafter, they did not pay me that amount. They only paid me 42,000. I approached your lordships and claiming the same claiming the area dues. So also interest, because they paid me after 18 years. 2001, I retired from service on voluntary retirement scheme, and in 2018, 42,000 was paid to me. I also claimed interest on the payment and also area salary. And
So that amount was paid in terms of apex court decision only.
No, apex court decision is, if you lordship kindly, yes, that was paid by the order of the Honorable Apex Court only.
7.3, Tara 7.3.
Yes, no. If you lordship kindly come to
Only thing is interest and some for 18 years.
18 years, and some amount is also payable to me, because that is not unpaid salary and the incremental dues from 1990 to 1998.
Who will assess it now?
No, that has been assessed by their audit by the Calico Spinning Mill.
Already there.
Yes, that audit is
They have to go for 33.
146. Page 146 is the audit report.
Money due from an employer.
PD Act.
Otherwise. If it is settled, amount is
If it is
settled.
settled,
Yeah.
33 C2. Issue. Who appears for the OPs?
Yes, 1 and 2, my 3 will appear. So for 3 is concerned, I can serve a copy of the
Request me to accept notice for 1 and 2. How many states of Odisha are here in your state?
Sorry,
Show emergent notice to 3.
I am accepting.
You appear for
OP3. Respondent of the
respondent appear for OP number 3. Matter lies in a narrow comfort, therefore was taking the 3rd week of March. Delay will condemn. Short delay of
3 days. 3 days only.
Application. The appeal is moved after approving a short delay of 3 days. First off, IA afforded by an affidavit offers due explanation, therefore, it is plausible. First off, therefore, application having been favored, delay is controlled.
So they'll be ready with TD in the next day.
We have paid everything as per direction of Apex Court. That is everything
belatedly. What should happen to 18 years?
Because after
an IR versus union of
They are sitting there bottom to the state. They said that state paid us late.
and that is they have paid.
Item 18.
There is a delay of 3 days in filing the
What's on merit?
Controlling authority under the Payment of Gratuity Act awarded an amount of rupees 10 lakhs towards gratuity amount,
with an interest of 10%, my lord.
Gratuity.
Gratuity, my lord. The same was confirmed by the appellate authority and was also confirmed by the Honorable High Court, this Honorable by the learned single judge. But the learned single judge interfered with the interest part, stating that your lordship may kindly have glanced at page 17.
Whether the payment of gratuity act provides for interest or not?
My lords, it provides for 10%, but the learned single judge said that since savings bank account are granting interest at 6% annum, so the petitioner should be.
How statute says a particular rate? How what discretion single judge has to reduce it? Issue emergent notice. Who are the OPs?
My lords, one
Cooperative bank.
Yes.
Notice has to go to one. 283, Mr. Behra. One only. Mr. Behra accept one.
No, my lord.
No,
238.
Notice 2. 1. Learned Mr. Behra, on our request, accepts notice for 283. First, matter lies in a very narrow compass. Therefore, calling up to service of notice. Okay.
Item 19? Item 19, similar matters.
Similar.
Your delay is 6 days.
Issue emergent notice. Call along it. Yes.
Item 20?
Same order.
No.
Costing. Yes, sir.
Item 20?
May I please, my lord? My lord, there are two matters. In one, the opposite parties have appeared. 54 days of delay, your lordship.
Opposite parties have appeared already. You are for OP2. MP1 who?
I am appearing for rest of the.
Will condone delay? Appeal is filed of a delay of
54 days.
54 days. First off. An application supported in a year of showing so support by affidavit accompanies the appeal members. First off. Delay is short and explanation of explanation offered is plausible. No objections are filed to the application. Rightly, first of all. Therefore, application having been favored, delay is called in the third week of March.
So the second matter also connected with
both the same.
Both are same. In that, what is the delay?
54 days.
Same.
My lord.
Common.
I'll give it.
Item 21?
Item 21.
43.
So intra-court appeal, my lord. Here, in fact, there is less merit in this case, honestly. The fact remains that the employee has.
Para 26 you read.
Yes, I had. Only to consider, the lordship have directed to consider it in accordance with 289(3) of the statute, that is Orissa University first statute, 1990. Nothing is there.
That was their statement is before the Honorable Single Judge. That was their statement. The state government had
supported your case.
Yes, they categorically para 10 also will see. It was the case of the officer state that
case of change of option. Either they are to remain as under CPF or accept the old pension scheme.
I think we decided one similar matter. I do not.
It's under university.
Decided. That's similar.
There is a deeming provision. Based on that, the Honorable Single Judge has held that to 218 because on his submission, he has submitted that my petitioner's case should be covered. Petitioner covered under 289. Dear Lord, there para 10 or 11 Lordship has categorically stated what is their contention, and accordingly, Honorable Single Judge has directed. Lordship kindly see para 10 of the internal page 21.
Since already taken the
that was the, if there is no.
That lady And where she committed fraud and suppressed on the.
There is no option based on the, there will be automatically deemed that he has opted for promotion. That's, and relying on the Supreme Court judgment, my lord, Honorable Supreme Court.
Option for getting pension, old pension or CPF.
Right. Right on. This intra-court appeal by the state and its functionaries seeks to call in question a learned single judge's judgment dated 3/8/2023, whereby respondent's WPC number 14751 of 2015 having been allowed, the following relief has been accorded to her or he, him, he. You write down and option the portion of the order. Yes, para 26 and 27 together. Next person. Learned hearing for the opponent when he argues that regardless of what has been stated in the regardless of the stand taken by the appellant before the learned single judge, correct legal position ought to have been ascertained, and thereafter relief of the kind could have been granted. This having not happened in the appeal, matter requires deeper consideration at the hands of this court. First, per contra, the senior advocate Mr. Mishra, appealing for the respondent employees, draws attention of the court to the specific stand which the appellant Benjalu had taken before the learned single judge, and therefore, once that stand is acted upon, rightly or wrongly, it is not open to them to continue to the contrary. First, next paragraph. So continuing this dismissal of here. What a delay is there?
No, there's delay had been pardon.
Next, having heard and
delay has been pardon.
He's retired in the meantime, Lord Sumay.
The appeal papers. We decline indulgence in the matter, broadly agreeing with the reasoning of the learned single judge as is reflected in para 26. 25 and 26. No, 24, 25, 20. It's covered by judgment of apex court of 24, 25, 26, which read as in the above circumstances, appeal being devoid of merits is liable to be rejected, and accordingly it is, courts having been made easy. Learned single judge's order shall be given effect within a period of 8 weeks.
Also, please.
Without being the responsible contempt proceedings or the like.
Item 22.
Yes, sir.
Item 22 is an appeal preferred by the state, my lord. There, the lordship may. I'm sorry. Lordship may kindly peruse for a moment 2 orders passed by their lordship. The petitioner, 2 dates are there, my lord, here. It is a matter relating to change of date of birth. My lord, it is, one is at the time of entry, whether scheme post which he was holding is a schematic post. First, Swachhasevi Shikha Sahayak. He entered into service, my lord, as Swachhasevi Shikha Sahayak on 15/7/2002.
2003. 15/7/2003.
3. Then there is a mistake in the judgment. Thereafter, my lord, he was regularized with effect from 17/7/2009. 17/7/2009.
37/2000.
My lord.
Anyway, going by
it was
record.
It was wrongly recorded as the date of birth of the petitioner was 10/10/63 instead of 10/10/65 in the service book. My humble submission is that, my lord, in terms of the 65 OGFR, my lord, date of birth has to be changed within 5 years from the date of entry into service, government service. My humble submission before your lordship says, if your lordship will hold that the 2002 is the date of entry into the service, then 5 years completed. If your lordship will hold that 2009 is the date of entry, then it is within the limitation of 5 years.
Date of, that is regularization date.
Regularization.
How the rule is structured? Read the rule.
Rule 65 of Odisha Civil Service, Volume 1, Finance Department Resolution dated 28/9/92.
How the rule is structured?
But that has been quoted in page 8 of their writ appeal. Every person, page 8, every person on entering government service shall declare his her date of birth, which shall not differ from any such declaration expressed or implied for any public service, public purpose before entering service. The date of birth shall be supported by documentary evidence such as matriculation certificate, municipal birth certificate, and entered in his/her service record. No alteration of the date of birth of government servants shall be made, except in case of clerical error, without prior approval of the state government. An application for effecting a change in the date of birth shall be summarily rejected if A, filed after 5 years of entry into government service.
Entry into government service means initial entry only.
No, here, my lord, I became a government servant.
It does not say you should become a government servant.
No, I was
entry into government service.
I was initially engaged as a Swechhasevi Shiksha Sahaya under a scheme.
You only had declared the date of birth. They did not tell you.
Well, here, as per my matriculation certificate, HSC certificate, my date of birth is 10/10/65.
Correct.
Well,
which one you declared?
No, my lord, your lordship may kindly turn to Annexure C/3 at page 10 of C/1 of my counter at page 10. In the service book, when service book was opened, I became a government servant. On 37/2011, my date of birth, third column, was wrongly entered as 10/10/1963.
That is the date on which you have furnished to them.
No, my lord, I have not furnished.
How they will know? They did not attend the delivery of your mother.
My lord, even assuming for the sake of argument, I have furnished that date of birth.
Correct.
My lord, then, since the service book was opened on 37/2011.
It does not say on the date the service book is opened. Rule is not concerned with your book pen.
As a government servant, government servant, your lordship is absolutely correct. As a government servant.
No, entry into government service. You need not be government servant because entry level, these things are decided at the entry level. What is your jet? What is your cash? What is your license? Which is your date of birth? What is your qualification? These are decided when you enter the gates of the employment. Not otherwise. Otherwise, it will not have sense only. As on the date, because this date is given not by the midwife, it is by you.
So far as opening of service book is concerned.
Makes no sense because there is nothing which is that idea is not internalized in the rule itself.
My lord is absolutely correct. My lord is absolutely correct.
Tomorrow everybody will change.
No, my lord. No. Here your lordship may kindly see.
Take out Vishwanatha Rao versus State of Karnataka.
Here my services were regularized.
78, 79, something like that. In Karnataka, there is Karnataka Civil Services Determination of Age Act 1974. And that matter went to Supreme Court. They take out that Vishwanatha Rao versus so and so. You give the date on a particular date. Suppose there was no requirement of furnishing the date as on the date you gain into entry. That would have not arisen.
Well, so far as the judgment of the Honorable Apex Court is concerned, the date of birth reflected in the HSC certificate or matriculation certificate.
Provided that is subject to limitation period. That's what subject got that judgment.
Yes. Well, your lordship is absolutely correct.
Within 5 years.
Here, my lord,
I applied for correction of my date of birth in 2012. After 1 year.
Not after
And that
1
is
year.
that has been
No, after 7 years perhaps.
But
You had gained entry on 15/7/2003.
no, as Swachhasevi Sikha Sahayak under a scheme.
That is entry.
So when you entered
By then service book was not open.
That was
when you
that
entered
was a
service in
schematic service.
2003,
Yes.
by then you had passed matriculation.
Well, I had passed matriculation in
And,
1984.
right, you have put your
1984. Well, 1984, I have passed matriculation from Bihar board. That I have given my certificate. But that was not required.
Individual, no, that makes no sense because what you
But service,
declared to the employer.
one thing, I address your lordship for consideration. My lord, since he was not a regular government servant, she was appointed under a scheme that is Swachhasevi Sikha Sahayak.
Could you get that judgment? It's Vishwanath Rao.
My lord,
State of Karnataka.
when her services were regularized on 17/7/2009.
We do not propose to that. We do not agree with that view at all. Entry point, when the gate was opened, what you told your employer, that will govern you. Unless you make an application within the time limit. That's what Vishwanath Rao says. Yes, Karnataka, State of Karnataka versus Vishwanath Rao. ILR 85 Karnataka, so and so, so and so. This decision went to court also.
The entry point, even
Point
not as a government servant.
As an irregular, no, that point is not there. They does not use the word government servant. Enter the service of the government. That's sufficient. That is sufficient.
But so far as Swachhasevi Sikha Sahayak is concerned, that is a schematic appointment.
That may be there.
So
Its opening sentence was that or no?
So
makes no sense.
mistake occurred there. And when my services were regularized in 2009.
Mr. Swain,
yes,
you are a very efficient service law lawyer. You should not spend so much time on this point. But we'll see some other good case when you appear.
But here your lordship, for a moment, your lordship, kindly see the findings of the learned single judge. One paragraph.
May not be necessary.
One paragraph.
After the date you gained entry to the portals of the employer, you had declared, my mother gave birth to me, and it was a great celebration.
Well, even assuming for the sake of argument, a mistake was committed by the appellant. A mistake was committed by the respondent.
Question is not mistake. Mistake is there.
Mistake is there.
Question is, for rectification of the mistake, what the law provides as limitation.
That is 5 years.
Question is not mistake or not mistake.
Yes.
There is obviously mistake because your SLC record gives the correct date of birth.
No, HSC certificate. Yes.
That's all.
Yes, absolutely correct.
Obviously, there is mistake.
Yes.
But certain mistakes in life do not admit rectifications.
But
that principle, this law is made.
But if that is at the fag end of service case.
No, not fag end. Law is law of limitation.
Law of limitation is there.
That's the question.
Here, my lord, you will also kindly visualize one thing. A primary school teacher who entered into service as a Swachhasevi Sikha Sahayak way back in the year 2003.
One more question, please.
Yes.
Suppose if this date is operated, will she get terminal benefits or not?
Well,
she will.
Well, only her date of retirement, that is.
She has already retired. She has already retired. Now we want her back.
That is as per 63. She has already retired from service on 31/10/2023. If my lord, the date of birth, that is 10/10/65 is taken into account.
Which we will not.
My lord.
Which we will not. Because.
But so far as the judgment of the Honorable Apex Court is concerned, my lord, emphasis is always given to the HSC certificate.
Correct.
No other date of birth.
Correct. It is only in the cases where age matters.
Age matters.
For the purpose of retirement, terminal benefits, etc. Even there, the Supreme Court said, if the fag end, if you want to alter, don't alter because.
Yes, fag end, it cannot be done. But even if mistake is there. And here, this is not at the fag end.
It makes no sense because law is taking care of the situation. Taking care of the situation.
Well, one judgment.
Yes, give that.
That is. It
You pass
HSC.
You had HSC when you get crashed the employer.
My lord, I passed.
We cannot say get because it's only backdoor.
I passed in 1984.
This Manoj Kumar, what you want to say?
My lord, Manoj Kumar, here, my lord, basing upon matriculation certificate, your lordship may kindly see paragraph 10.
Always matriculation certificate is a primary document evidencing date of birth. We don't dispute that. It's a primary document. Question is, on which date you are born is not our concern. It is the maternity home.
Yes.
Not us.
Yes.
Question is, whether once you declare a date, can it be altered or not is the question. Nothing else
It
is
should be within 5 years.
Within 5 years.
Within 5
years. To be reckoned from which date is the question.
Yes.
To be specific. You say it is the date on which she becomes the regular employee.
Regularized.
We say it is not like that. Date
From
of
the
birth
initial
cannot
engagement.
change.
From the initial engagement.
From the initial engagement.
But
Declare it.
so far as OGFR is concerned, it says that from the date of regular government service.
No.
Your lordship may kindly see.
Not there.
Not
Entry into service.
My lord, may kindly.
Entry. That
Again, I
conspicuously absent.
My lord, again, I would read.
You read.
Every person on entering government service.
Does not say.
Entering government service.
Entering government service.
That's it.
So far as Swachasevi Sikha Sahayak is concerned, that is not a government service.
Well, who will pay that?
But that is not a government service.
Comment.
They are getting remuneration. No, they are getting remuneration.
The question is, how are you going to decide whether it's
But that is not a employment. That is not a regular appointment. That is an engagement.
No, that makes sense.
That is an engagement. You will also may kindly see the.
In who is the premises you will work? In the government premises?
Government premises I will work.
Number 2, who will pay you?
My lord, the
government.
Block education officer.
So government.
Remuneration, only remuneration.
It does not depend upon what you call as salary, remuneration, wages, consideration, price, etc.
And that is that is a contractual engagement. It is being renewed from year to year.
We'll allowed on the following notes. The entry point of service, whether regular, irregular, or otherwise, is the focal point of the Rule 65 of Odisha Civil Services. So, first one, the rule employs the expression. Appoint what it you just told.
Initial engagement.
The government service. And does not say entering the government service on regular recruitment. First one. It is the employee, regardless of his status, would declare what his date of birth is. First one. If he wrongly declares, he should seek its rectification within the limitation period prescribed by law. First one. Once that period expires, right or wrong of the entry makes no difference, law being what it is. First one. Solomon on Jurisprudence, 12th edition by Fitzgerald, says the law of limitation is a law of repose and peace. Second, it enacts a policy of the state. First one. This aspect having been lost sight of, there is error apparent on the face of the impugned judgment, and therefore our interference is eminently warranted. First, writ petition, writ appeal allowed, and writ petition dismissed. Court Vishwanath Rao, the state of Karnataka versus Vishwanath Rao.